Lauren Adelsman here?
She's not here. She's going to be participating next week in the false confession aspect of the hearing.
Okay, because we didn't have the approval yet from the state of Michigan.
Right. She followed up. I know I saw email traffic following up yesterday, so we'll get back to you as soon as possible.
Okay, thank you.
No problem.
Are you gonna want Ms. Boes there in the front table?
You know, I'm going to actually go to the back table. Ms. Bruce can sit with. So
Do you need another chair?
we already pulled one. Thank you.
Okay.
Let me bring Ms. Boes in. All right, is she gonna have a seat at the back table?
Yes.
All right, go ahead. All right, we are back on record now in regard to people of the state of Michigan versus Karen Boes. This is case number 02-26455-FC. We're here today for an evidentiary hearing. I'm going to have the attorneys identify themselves first. We're going to start on the prosecution table. Go ahead.
Yes, John Donaldson on behalf of the people, and seated with me is James Lord, who's the expert who I'll be calling. I've spoke before, went on the record with the other side, and we are in agreement that since there's a lot of expert testimony going on, that the expert who's not testifying can stay in the courtroom while the others testify.
All right, so James, what's the last name?
Lord.
Ford, okay, thank you. All right, and then on the defense table or the Innocence Project table, you may go ahead and identify yourself one at a time, please.
Sure. Good morning. My name is Jenna Cobb, and I'm with the Michigan Innocence Clinic representing Ms. Karen Boes. I want to move for the admission of a student attorney to practice for the purposes of this hearing under Rule 8.12. That's Mr. Lachlan Charles.
Is he going to be making any statements or anything today?
He will be doing a direct examination.
Okay, go ahead and say what court rule you rely on.
Michigan Court Rule 8.12. 0.
There you go.
Apologies.
All right, so does he have a passing grade going on in law school?
Absolutely.
And what year is he in?
He is in his second year.
All right, so I'm gonna ask him, who's standing, to raise your right hand. You solemnly swear or affirm the information you give today will be the truth?
Yes, Your Honor.
Go ahead and state your full name.
Lachlan Philip Charles.
Lachlan's your first name,
Yes, Your Honor.
and then Charles your last name.
Yes.
Okay, where do you go to school?
University of Michigan Law School.
All right, so have you been working on this case for a while?
Yes, Your Honor.
Let me put your hand down. How long have you been working on the case?
Since August 2025.
What's the plan today as far as your participation here?
I'll be direct examining our first witness, Mr. John Lentini.
Is that the only one you'll be examining?
Yes, Your Honor.
All right. Do you have any objection to the law student proceeding in that way, Mr. Donaldson?
No, Your Honor.
All right, so you may have a seat. Thank you.
Thank you, Your Honor.
Right, and then who else is at the table?
Morning, Your Honor. Imran Syed, the Michigan Innocence Clinic, on behalf of Ms. Boes.
Say your name again, please.
Sure, it's Imran, spelled I-M-R-A-N. Last name is Syed, S-Y-E-D.
That's why ED.
That's correct.
Thank you. All right, is there anyone else who's an attorney that wants to make us identify themselves in this case?
So, Your Honor, we have another student attorney on Ms. Boos's team. She won't be speaking this week. It'll be next week that we will be moving for her admission. And then we have our expert, Mr. John Lentini, sitting at the table as well.
All right, what's the expert's name again?
John Lentini,
Spell the last name.
Lentini.
All right, thank you.
Thank you, Your Honor.
All right, so the court did receive motion for temporary admission to practice. That was from Lauren Gottesman, Gottesman, who is with the Innocence Project in New York, who made a request to appear today and participate. However, the State Bar of Michigan has not presented any sort of letter on her behalf, so we're waiting for that. The court's understanding from going on the record before, from having conversation before going on the record, is that she plans to be here next week, and hopefully we'll have the proper paperwork at that time. Is that correct, Ms. Cobb?
That is correct, Your
All
Honor.
right, thank you. All right, is there anything else to take up before we get started, Mr. Donaldson?
No, Your Honor.
Anything else, Ms. Cobb?
So, Your Honor, we have or the prosecution has stipulated to the admissibility of our exhibits. And so we have them, we are currently labeling them. In effort to streamline the hearing, we provided them to the prosecution in advance of the hearing, and they have no objection.
All right, is that correct?
Yes, Your Honor. I was provided a link that had attached 41 exhibits to it, and I will not object to those being admitted.
All right, thank you. All right, anything else, Ms. Cobb?
No, thank you, Your Honor.
All right, thank you. So then, the person that will present testimony here is Mr. Donaldson or Ms. Cobb, who's going to be presenting?
Your Honor, it's their motion, so they would go first, I believe.
All right, thank you. All right, so Ms. Cobb, you may go ahead and call your first witness.
I'm calling Mr. John Lentini.
You may come up here, and if, Ms. Cobb, if you want to go to the podium, it records a little better there, so when you ask questions, if you'll go there, that would be helpful.
Sure, and this is actually where Mr. Charles will be asking the questions.
All right, thank you. Raise your right hand, please. Do you solemnly swear or affirm the testimony you give today will be the truth?
I do.
Thank you. You may have a seat. And go ahead and state your full name.
John Joseph Lentini,
And spell your last name.
Lentini.
Thank you. All right, you may proceed and ask questions, Mr. Charles.
Thank you, Your Honor. Good morning, Mr. Lentini.
Good morning.
What is your occupation?
I'm a fire investigation consultant.
For whom do you work?
I work for myself. My company is called Scientific Fire Analysis, based out of Islamorada, Florida.
And what is it that scientific fire analysis does?
We consult with, or I consult with, attorneys who have litigation or potential litigation involving fires.
Does your company also evaluate prior investigations done by other investigators?
That is almost exclusively what I do these days.
And how long have you been associated with scientific fire analysis?
20 years this year.
And what did you do prior to starting scientific fire analysis?
Prior to that, I worked for 28 years for Applied Technical Services. It's a multidiscipline consulting and testing firm based in Marietta, Georgia. And I managed that firm's business related to fires, arsons, explosions, and asphyxiations.
And in terms of years in fires investigated, how much experience do you have as a fire investigator?
50.
And in terms of fires?
I stopped counting at 2,000, when I reached 2,000 fire scenes that I had personally visited and been responsible for determining the origin and cause. I did 2,000 of those.
What are your professional affiliations as a fire investigator?
I'm a member of the International Association of Arson Investigators. I have served on their Forensic Science Committee. I'm a member of the American Academy of Forensic Sciences. I'm a member of ASTM International, which writes standards for fire debris analysis. And I'm a member of the National Fire Protection Association, where I served 20 years on the committee that writes NFPA 921, Guide for Fire and Explosion Investigations. I currently serve with NFPA on their Fire Investigation Professional Qualifications Committee.
In addition to fire investigation, do you have any experience or training in fire debris analysis?
Yes, I've been certified in fire debris analysis by the American Board of Criminalistics. I had that certification from 1993 to 2008, and I'm now just certified as a general criminalist with the American Board of Criminalistics.
Have you been involved in the development of fire investigation standards?
Yes, that's been a major focus of my career since the 1980s.
How so?
In the 1980s, I was approached by the president of the International Association of Arson Investigators as chair of the Forensic Science and Engineering Committee, and I was requested to write a standard for reporting on fire debris analysis. And as we undertook that task, it became clear we needed to first come up with a standard for how to conduct fire debris analysis before we talked about how to report them. So I was the principal author of that standard within the IAAI, and later that standard was adopted by ASTM Committee E30 on Forensic Sciences. So it became our one standard in the IAAI became 7 standards within the ASTM standards hierarchy. ASTM is a standards development organization. It's accredited by American National Standards Institute. Unlike the IAAI, which they're not a standards development organization as such, they're just a professional organization. So, and I chaired the ASTM subcommittee on criminalistics and later became the main committee chair for 2 terms within ASTM.
Please list any major relevant publications you've had, including books, book chapters, and articles.
I've got 2 books. The first one's called Scientific Protocols for Fire Investigation. It was first published in 2006. The second edition came out in 2013, and the third edition came out in 2018. In addition to that book, I've written several book chapters for colleagues who were writing books on forensic science, and I have approximately 50 publications, some of which are peer-reviewed and some of which appeared in the IAAI journal. So they were more trade journals as opposed to peer-reviewed scientific articles. But I've written several of those that are standard works in the field.
Other than your book, what publications do you feel are the most significant?
Well, with respect to this case, it would be my historical perspective article that I wrote in 2019 about the history and development of fire investigation and standards for fire investigation. I've also done a couple of esoteric chemical analysis papers, one on how much petroleum we find in our background, another one on the persistence of solvents in floor coatings, and finally there was one where I solved the problem of how to tell the difference between kerosene and asphalt.
Has your work in the fire investigations field received professional recognition?
It has. In 2024, I received the AAFS, that's American Academy of Forensic Sciences, Paul L. Kirk Award. In 2015, I received the Society of SFPE, Professional Engineers, Society of Fire Protection Engineers. I was named the Person of the Year for my work in the courts. That's an award that SFPE gives to people who are not members. So outside. I've got a couple of other awards from ASTM as well.
Your Honor, do I have permission to approach the witness?
Just make sure that your voice is being heard, because Dawn will let you know if you're not speaking loud enough and away from the microphone.
Will do, Your Honor. Mr. Lentini, can you please identify the document I've just handed you?
This is a current version of my resume or CV.
Your Honor, to be clear for the record, this has been stipulated to as Defense Exhibit A.
Do you agree with that, Mr. Johnson?
Yes, Your Honor.
Okay, you can do it then.
Mr. Lentini, I'd now like to talk to you about your involvement in this case. Were you contacted by the Michigan Innocence Clinic to review a case about a fire that took place at 523 William Street in Zeeland, Michigan?
I was.
When did they contact you?
I believe it was 2018.
Do you know when in 2018 they contacted you?
I wrote it down. I didn't memorize the date. It's in my report.
If I said May, would that sound correct?
It sounds right.
What did they consult you on?
They wanted me to address new science that had been adopted since the, I guess the last litigation in this case, which was 2006. And Mr. Moran, who was running the Innocence Clinic at the time, he wanted to know what's happened since then that is different from before then.
Have you done reviews like this in the past?
I have.
And when defense attorneys reach out to you for your help on a case, do you always provide them a favorable opinion?
Oh, no. I provide them my opinion, which is what they're paying me for. But 3/4 of the time, I tell them that I can help you avoid being ineffective, but I can't really help you by testifying in this case.
Are you typically compensated for your time reviewing cases?
Oh, yeah. Charge regular folks $3.50 an hour, public defenders $2.50 an hour, but in this particular case, I accepted it on a pro bono basis.
What materials from this case did you review?
I reviewed the trial testimony, particularly the expert testimony in the case. I reviewed the autopsy reports. I reviewed all of the photographs that were made available to me, and I reviewed the history of NFPA 921 and how different subjects were addressed and when they first became addressed.
Do you recall the names of the experts whose testimony and reports you reviewed?
Yeah, there was ATF Special Agent Michael Marquardt, Dr. John DeHaan, and then Mr. Stromzand, who was an expert for the state.
And have you read the report of Mr. James Lord?
I have.
And after reviewing the materials from this case, did you create a report?
I did. Now, I didn't see Mr. Lloyd's report until after I wrote my report.
You testified earlier about NFPA 921. What is NFPA 921?
It is a guide for fire and explosion investigations that was first published in 1992 by National Fire Protection Association, also known as NFPA. They convened a technical committee, which is a group of experts, back in 1985 to develop a guide for fire and explosion investigations. And after 7 years, they produced the first edition in 1992. And then there was one in 95, 98, 2001, 2004, 2008, 2011, 2014, 2017, and the last two, which happened after I left the committee, 2021 and 2024. So every 3 or 4 years, they update the document. And the idea is that when they make changes in the document, it's got to be good science or they're not going to change the document.
What was the first year?
First year was 1992.
You said something about 1982, what was that?
In 1985 is when the committee was first instituted by NFPA and tasked with developing a guide for fire investigation.
Thank you.
And to be clear, did you serve on the NFPA 921 committee?
Yes, I participated as a member of the public in the 1992 edition, and then after the 1995 edition was put to bed, I became a full voting member of the committee, and I served on the committee through 2016.
And what exactly does NFPA 921 address?
It addresses all aspects of fire investigation. It starts out with basic fire science. First it starts out with a scientific method, then it goes into basic fire science, fire patterns, electricity, gas, building systems, and specific types of fires. It has a chapter on origin determination and a chapter on cause determination. It started out, it had just over 100 pages, and right now it is just over 500 pages.
And what is the role of NFPA 921 in the fire investigation community today?
It is generally considered the standard of care for fire investigations. There's a quarterly magazine put out by the International Association of Arson Investigators. Every quarter they say, 921 is an authoritative source.
Did you consult NFPA 921 when reviewing the fire scene and work by previous experts in this case?
I did.
What editions did you consult?
The 2001 edition, which was the operative edition when this fire happened and was first investigated. The 2011 edition, which is the first time that the committee addressed the subject of negative corpus methodology. The 2017 edition, which was the first edition that really focused on ventilation of fires, and then, of course, the current edition is to see what the state of the art is.
Can you describe for the court the methodology that NFPA 921 prescribes for fire origin and cause investigation?
It embraces the scientific method, which involves first defining the problem and collecting data and analyzing the data, then developing, after that analysis, developing a hypothesis, then most importantly, testing that hypothesis against all the data, and finally arriving at a final hypothesis.
In analyzing the state's expert testimony in this case, did you apply NFPA 921's methods?
I did.
And in reaching your own conclusions as to this fire, did you also apply those principles and methods?
I did.
Your Honor, with that foundation, I move to admit Mr. Lentini to this court as an expert in the field of fire investigation and in the development and implementation of fire investigation standards.
Do you have any objection to that?
Your
Mr.
Honor,
Dawson?
ask some questions related to the qualifications.
Yes, you may. Go ahead with your question, Mr. Donaldson.
As part of fire investigation, you testified that the NFPA 921 is an important document that you use when conducting investigations. Is that correct?
That's correct.
Okay. And isn't it true that in 2011, a judge in New Hampshire ruled your testimony invalid because you failed to follow NFPA 921?
That judge was later overruled by the subsequent judge, but yes, that's true.
Okay. And that's because in your book and in prior testimony, you've indicated that when you review fires, you go into them presuming that they are accidental.
I say that that is the presumption that a fire investigator should take into a fire. Of course, in this particular case, there's no question it's an arson fire, so that doesn't really apply here.
But my question is, you go into investigations assuming they're accidental. Is that correct? Or you've indicated in your book?
I have to overcome a presumption that the fire was accidental, which is actually the law in 18 states.
And that presumption is run afoul of NFPA 921, is that correct?
Say that again?
That presumption runs afoul of what is prescribed in
It
NFPA
does.
921.
It does.
So you do not follow NFPA 921 when you conduct your investigations?
That's not true. That's one aspect of NFPA 921 that I disagree with.
And that's that you go into fires presuming them to be accidental?
I do. I go in with a presumption that we have an accidental fire and try very hard to overcome that presumption.
And in fact, you've tried to change NFPA's manual to adopt your line of thinking in that, is that correct?
I did.
Okay, and that was rejected by the fire community?
It was.
Okay. And in fact, there was a peer-reviewed document created denouncing or rejecting your claim, is that correct?
I have no idea what you're talking about.
So despite your attempt to change NFPA 921, you still don't follow and use that assumption?
I use every bit of NFPA 921 except that part about my attitude going into a fire.
So you reject the part of NFPA 21s that you don't agree with?
Sure.
I have no further questions.
All right, so what's your position, Mr. Donaldson, in regard to the request to accept this witness as an expert?
I no objection.
All right, so then this witness will be accepted as an expert in the areas requested.
May I proceed, Your Honor?
Yes.
We'll discuss details shortly, Mr. Lentini, but can you give a brief summary of what you concluded after reviewing this case?
Yes. The fire originated in the bedroom. The proposition that the fire originated in the hallway is unsupported by the evidence, and the methodology used to determine that the fire started in the hallway was invalid and involved the use of negative corpus methodology. It also failed to properly account for ventilation, and it also failed to account for what would happen if somebody poured gasoline in that hallway and how long it would take. And that's basically it.
Mr. Lentini, you testified earlier that NFPA 921 was published for the first time in 1992. Why was it created in the first place?
There were a lot of problems with fire investigations prior to 1992. My understanding is that the original impetus for forming that technical committee was input that the NFPA Standards Council received from the National Association of Electrical Manufacturers. And back in the day, when people couldn't figure out the cause of a fire, a lot of people would just throw their hands up and say, it must have been electrical, which had offended the electrical manufacturers. They complained to 922 NFPA, and NFPA convened the committee as a result.
Were there any myths or misconceptions in the fire investigation community?
There were a ton of them, and that was the major thrust of the first two editions of NFPA 921. They had numerous paragraphs with a heading that said misconceptions about spalling, misconceptions about V patterns, misconceptions about various artifacts in fire investigation that investigators believed to be true, but it turns out that when these propositions were tested, they were found to be false. There was one example is crazed glass. This is something that happens to glass when it gets hot and then it gets wet. And for years, people thought that crazed glass meant rapid heating without actually defining what rapid meant. And some people wrote in textbooks that if you see crazed glass, that means there's accelerants nearby. And it was total invalid. It was just totally invalid. I did some experiments after the major fire that happened in Oakland, California in 1991. And I proved that crazed glass could not be the result of rapid heating, but could only be the result of rapid cooling. And that was incorporated into NFPA 921 over the years.
Sorry.
There was also, people used to think that if concrete was spalled, and that is an explosive chipping up of the surface, that meant there were flammable liquids on the concrete. Totally false. In fact, you can't make concrete spall using flammable liquids, but you can make it spall using ordinary combustibles. So a lot of people just had this misconception. There were other misconceptions about V patterns. If you have a very simple fire, if I were to take a piece of paper and put a match here, it would burn up and out on the paper in a V-shaped pattern. So presumably I go to the bottom, and that's the origin. Well, that's true in this simple case. But in a fire, as materials on the ceiling burn, they fall down, and they burn up from there. And so you get all these secondary effects that really don't mean anything as to what caused the fire. So people would see two V patterns and they would say 2 points of origin. Well, that's just not necessarily so.
Were all investigators in your industry aware of these myths?
Most of the investigators, including myself back in the day, believed some of this stuff. I used to believe the myth about spalling until I did some testing and some research. It was very common, and when 921 came out and said to the fire investigation community, hey, this stuff you're doing isn't valid, the fire investigation community's collective heads exploded. So NFPA 921 was not generally accepted when it first came out. And a lot of people just didn't like being told you have to do science in order to do a good fire investigation.
Once NFPA 921 was published, did fire investigators immediately stop relying on those myths and misconceptions?
No, not at all. They insisted on their ability to continue using those, what they call tools. And it's totally understandable that if you've sent someone to prison based on crazed glass and spalled concrete, that you don't want to admit that those things aren't meaningful.
Were there any efforts to get rid of NFPA 921?
There were a number of them, and they actually were centered in Michigan. For the 2001 edition, there were over 170 comments that came from Michigan, people in Michigan, objecting to 921. Some of them said, take the word science out. And this was a big argument, and this is the year 2000. And the committee was urged to talk about a systematic approach as opposed to the scientific approach. That was rejected. So it wasn't until 2000 that the International Association of Arson Investigators actually signed on to NFPA 921. Prior to that, they had objected to it because a couple of cases had taken place where fire investigators' testimony was excluded as a result of not following the scientific method. And the IAAI objected to that. They went so far as to write an amicus brief saying that fire investigators should not be subjected to what they called extraneous questions about the scientific method. And those comments and proposals were generally rejected by the committee.
Do you know if any of those Michigan State fire investigators you were talking about were involved in this case?
One of them, Mr. Stromsen, did submit some proposals to change NFPA 921 prior to the 2001 edition.
And how do you know this?
I was on the committee. When somebody writes to the committee and participates in this standards development process, the committee is required to address each and every comment or proposal that comes to it and provide a justification for why a particular comment was either accepted or rejected.
Your Honor, do I have permission to approach the witness? Mr. Lentini, I've just handed you what has been stipulated to as Defense Exhibit B. Can you please identify this document?
Yes, this is from the report on comments, which was issued by NFPA prior to the adoption of the 2001 edition of NFPA 921.
If you flip through the pages I've handed you, there's a name that I've highlighted. Can you please identify that name?
The name is Gregory Stormsend of the Michigan State Police.
Can you please take a moment to read the comments under the highlighted name and let us know when you're finished?
Yes, I've finished them.
Having read them, what do you understand his position to be at the time he submitted these proposals?
He didn't think we should be using science. He said science is not the only way to investigate a fire.
Your Honor, I'd object to speculation, asking what his opinion was. He can read what the comments were if he wants, but I don't think he should be getting in his mind trying to guess what his reasoning was.
Do you agree with that?
Your Honor, may I take a moment to confer? Your Honor, Mr. Lentini is an expert in interpreting these comments as he was on the NFPA 921 technical committee that these were submitted to, so he should be able to both read the comments and explain what he believes they mean.
He can read the comments, but as far as his interpretation, I don't want him to pretend to know what that meant, so he may read the comments if he wishes to.
Mr. Lentini, can you please read the 4 comments I've highlighted?
Sure. The committee had rejected a proposal to change scientific to systematic, and Mr. Strum then wrote that we should have accepted it. And his substantiation was it clearly clarifies the position of the document as a guide as stated on the front cover and removes the confusion so often raised in court setting about the use or misuse of the document as a standard as opposed to a guide.
So his recommendation on that particular, the first comment is that to accept this proposal, correct?
Right. The committee at the proposal stage rejected a proposal that came to it, and Mr. Stormson said, you should have accepted that. The second proposal, again, it was about use of the scientific method. The committee had said, if you use the techniques, you got a better chance of succeeding if you use this model. And the committee had accepted that proposal, and Mr. Stormson said, you should have rejected it. He said this proposal would only add confusion and excess language. The book is to be used as a guide. The term model implies that it is authoritative and that it contains mandatory provisions of activity, which it does not. That was rejected. The third proposal, again, it was a proposal that we had rejected, and in his comment, Mr. Stormson said, you should have accepted that. And he said, this proposal clearly defines the method of investigation without confusing the issue. Fire scenes are dynamic and are not laboratories, and fires are not controllable nor the results. And the committee had a discussion of that and rejected it. And finally, there was another proposal accepted that Mr. Stormson said should have been rejected. He said, this proposal is a confusing attempt to justify that the scientific method is the only proper method of fire investigation, instead of just saying a systematic method. However, when the word scientific method is used, it is generally thought as something done within a laboratory setting. And can the fire scenario be specifically tested time after time to get to the same results to verify your conclusions? And the committee again rejected that.
Thank you. Despite the pushback you described, did NFPA 921 eventually gain wide acceptance in your profession?
It did. Around the year 2000, the International Association of Arson Investigators accepted NFPA 921. And it was generally, it can be said to be generally accepted after the 2001 edition was published. Prior to that, you couldn't say it was generally accepted.
And how do you know this?
I was on a committee. I was practicing day in, day out in fire investigation.
Now I'd like to ask you some questions about the report you wrote for this case.
Yes.
In your report, you mentioned flashover. Can you explain to the court what flashover is?
I can do it better with pictures than words.
I have it up. Oh, do not have it plugged in. That's going to be fun.
One moment.
For the record, I am not projecting what has been stipulated to as Defense Exhibit C.
Are you agreeable with that, Mr. Johnson?
Yeah, sure.
Mr. C is agreeable.
Yeah.
Mr. Lentini, can you please describe to the court what flashover is? And we can bounce around through slides as needed.
Flashover is a transitional period in a development of a compartment fire, an inside fire, that is completely different from ordinary people's experience of fires, because most people only see fires when they're outside, campfires, trash fires, brush fires. When a fire is placed in a compartment, its behavior is completely different from how it behaves outside. Exhibit 3 is the first of 5 drawings that were in NFPA 921 from the first edition until, well, this one is still there now. So these set of drawings have been very much standardized over the years. But what happens, everybody knows that heat rises. But if you have it inside, it can only rise until it hits the ceiling. And then it forms a layer of hot gases. And much of what is in there, the smoke, is combustible. So then the next step after this, go ahead and put up the next slide.
And for the record, this has been stipulated to as Defense Exhibit D.
All right, this is marked as Exhibit 4, but this is Exhibit D.
Yes, Your Honor.
Are you gonna put D on there somewhere?
We have a printed version that we are labeling correctly. Apologies, Your Honor.
All right, thank you. Go ahead.
This just shows the development of the hot gas layer underneath the ceiling. And the room fills up like it was an upside down bathtub, filling up from the ceiling coming down. And as the fire burns, it continues to put both products of combustion and energy into that hot gas layer. And the other thing this shows is that the smoke, if it's got the opportunity, it'll leave the room at the top, and then that will cause a partial vacuum that will suck in fresh air at the bottom. You can go to the next one.
And for the record, this has been stipulated as Defense Exhibit E.
Right. This is a drawing from the 3rd edition of my book that makes it a little more colorful and a little easier to understand than just the drawing from NFPA 921. But it talks about how the smoke layer banks down, filling the upper portion of the room.
And for the record, this has been stipulated as Defense Exhibit F.
Yeah. Now we're back to NFPA 921. And this is the 3rd drawing. Those are my words at the top. It said radiation sends heat down. But the point of understanding this is that heat doesn't always rise. At this point, radiation becomes the major means of heat transfer in the fire. And so that hot gas layer is sending heat downward. And that is totally different from most people's experience. And you know, for years, people said, oh, fire burns up. If it's burning on the floor, it must have had help in the form of an accelerant. And this was common wisdom throughout the 80s and much of the 90s, that floors don't burn. And we can go to the next slide.
And for the record, this has been stipulated to as Defense Exhibit G.
Right, and this is approximately the same drawing, only in color. And, it shows how the cool outside air gets sucked in at the bottom, and the heat and the smoke goes out the top. And the temperature in the room is gradually rising, so that put up the next slide.
And for the record, this has been stipulated as Defense Exhibit H.
So what happens here is when the temperature in that hot gas layer gets to around 11 or 1200 degrees Fahrenheit, it's throwing off so much radiation that it will ignite other items in the room. So while the fire started on that center fuel package, there are 2 other fuel packages in the room that are now getting hot enough to do what's called pyrolyze. The big molecules in the wood or the plastic break into little molecules which are volatile. They become liquids and then vapors. And those vapors are what burns when anything burns. Go to the next slide.
And for the record, this has been stipulated as Defense Exhibit I.
And this is now we're back to NFPA 921, and this shows how all of the fuel packages in the room are exposed to that radiant heat and they can catch on fire. And the floor can actually catch on fire at this point. And it took a long time. And in fact, there's still some people that, when they see burning on the floor, they say, oh, low burning. That's suspicious. In a fully involved room, it is not even a little bit suspicious. And then the next one.
And for the record, this has been stipulated as Defense Exhibit J.
Okay, this is the drawing from NFPA 921 that was used in the 1992 through 2014 edition. So that's like 8 editions in. This drawing was still used up until 2014. And between 2014 and 2017, it dawned on the committee and the scientific community in general that not only does the floor burn, but when that fire involves the whole room, it uses up all the oxygen in the room. And so we changed the drawing in the 2017 edition to what is shown, I hope, on the next slide. There.
And real quick, Mr. Lentini, for the record, this has been stipulated to as Defense Exhibit K.
So what's happened here, the chair on the left, on the far left of this photograph, this drawing, that was the origin of the fire. But that chair is now no longer in flaming combustion because there's not enough oxygen where that chair is. And on the other side of the room, the second chair on the right, that's got an oxygen supply. So it burns. And left unchecked, it might end up with that second chair being damaged worse than the first chair where the fire started. And people would look at that and say, that's where the fire started, because it's more heavily damaged. And so this was a major change in NFPA 921. It took place over a number of years as a result of scientific experiments that were done, starting in, the first public one was 2005, where people understood after that event that the oxygen concentration is what controls the fire at this point in its existence.
And on the next slide has been stipulated to as Defense Exhibit L.
Yes, this is some work that was done by Underwriters Laboratories Fire Safety Research Institute. And this work started in 2016. A committee was convened by Daniel Madrikowski, who is a leading fire expert. He works with Underwriters Laboratories. And what these charts show is the progress of a fire. Each one of the lines in the top chart is just measuring temperature at different heights below the ceiling. And although it starts out where there's lower temperatures for some of the measuring devices near the floor, by the time you get to flashover, all the temperatures are the same, from the ceiling to the floor. The other thing, in the bottom chart, we show the oxygen concentration, starting out at 20.95%, 21% is close enough. And as soon as flashover happens, the oxygen becomes depleted to where it's less than 5% at some point, at some places, and certainly several of them are less than 10%. And you can't have flaming combustion at that point. So you can have heat, but you cannot have flaming combustion when you get down below 10% oxygen in the room. So, and this is kind of, people thought this might be the case, but this is the first time that I know of that it was actually measured and demonstrated that the oxygen drops off when the flashover occurs.
And on the next slide is stipulated Defense Exhibit M.
All right. This is a test fire that demonstrates a number of issues about flashover. What we see here is a chair that was set on fire 145 seconds ago, so 2.5 minutes or so. And you can clearly see the hot gas layer developing above the, or below the ceiling. And then 50 seconds later, so less than a minute later, you can show the next slide.
And for the record, this has been stipulated as Defense Exhibit N.
And this is flashover occurring. And this shows what the drawings had showed earlier. One thing that is very important about this is that this room only has 3 sides. So even if the confinement with respect to walls is not complete, you can still get flashover occurring. So the fact that, you know, you're only partially confined, as long as you got a ceiling, you can have, or some kind of confinement, you can have the flashover occurring. And then the next slide.
This has been stipulated as Defense Exhibit O.
Okay, this is that fire after it's put out. And there is a common misconception that because everything happens at once during flashover, that the damage is uniform. And as this slide quite clearly shows, the damage is anything but uniform here. So you can look at it. At this point, you can tell that the fire probably started on the chair on the right. But the damage is not uniform at all.
Do all fires reach flashover?
No, only fires that become fully involved reach flashover. And in fact, you can get to full room involvement without flashover. And really the thing that confuses fire investigators is not flashover artifacts, but full room involvement artifacts. Once that room is fully involved, that's what we're looking at. Flashover is over in just a few seconds, but full room involvement can continue until it either runs out of fuel, it runs out of air, or the fire department puts water on it, puts it out.
And for those fires that do reach flashover, how long does it take?
It can be as short as 3 to 5 minutes. And if you got accelerants, it can be even shorter than that.
In your report and in your testimony today, you've used the term fully involved fire. What does that mean?
That means that the fire is as big as it's going to get, given the limitations of the fuel and the oxygen. So it just basically fills up a whole room. But once a fire becomes fully involved, the rules for interpreting post-fire artifacts change. You really, really have to consider, where's this fire getting its air? Why is it burning more in one area than another? And frequently that's a result of there's ventilation in one part and there's no ventilation in another part.
Are there any specific conditions needed for a flashover to occur?
I'm sorry?
Are there any specific conditions needed for a fire to reach the flashover phase?
Well, you just got to have that hot gas layer, and it has to get hot enough. It has to get up to 11 or 1200 degrees Fahrenheit. And then you have it.
How long have fire scientists been studying flashover?
Probably since the 1980s. That's when it became a known thing. NFPA put out a film called Countdown to Disaster, and they described what happens. They did a video showing a simulated cigarette fire and how it brought the room to flashover in under 4 minutes. So back then, though, the fire protection engineers that were running these tests, number one, they were not talking to fire investigators. And number two, they were interested in when is flashover going to occur, how can we slow it down, what's going to happen during flashover. But they never went in afterwards and looked at the artifacts on the floor. So this beautiful video that shows flashover doesn't show you the floor afterwards. And this wasn't being communicated between fire protection engineers and the dirty knuckle guys with the boots on the ground. They were not talking to each other until NFPA convened the Technical Committee on Fire Investigations.
Has flashover been a controversial topic in the field of fire science?
Yes, it was very controversial in the 1990s. There were trade journals that aired the controversy, and in fact, people used to think burning on the floor meant accelerants, and so people that believed that called flashover, they derided it as the flashover defense. And this was how they said, well, I can still say that that's caused by a flammable liquid, even if the laboratory is negative. It's not supposed to burn. And then people like me began looking at flashover and think, you can burn the floor in a flashover without any flammable liquids. And so that was fought, pretty frequently during the 1990s.
Are you aware of how the knowledge of the average investigator has changed over time regarding flashover?
Yeah, nowadays, the average fire investigator, NFPA 921 is a fact of life. But back when 921 first came out, it was not a fact of life, and a lot of people didn't like it. So the average guy in the field did not get what was being worked on at the Center for Fire Research or at the ATF. They didn't understand it, and it was non-scientists who didn't want to be scientists, didn't want anything to do with science, mainly former firefighters. They did not want to be held to any standards, and they really didn't want to know about flashover.
In your report, you alluded to the fact that investigators often misread burn patterns after flashovers occurred. Why is that?
Because they look for the lowest and deepest char, and they say, well, it burned a lot here, so it must have been burning longer here. And the problem is that it can be extra heavily damaged because it burns more intensely as opposed to for a longer period of time. And it's difficult to separate intensity and duration.
Why is that important?
Well, these fire patterns don't come with timestamps on them. And we as fire investigators, we want to find the first fire pattern that was created. We really don't care about an intense fire pattern that was created an hour after the fire started or even 20 minutes after the fire started. We're looking for the pattern that was created when the fire first started.
Can an investigator correctly determine the cause of a fire if they don't correctly identify the origin?
Generally not.
How can you tell when a flashover has occurred?
You look for charring on baseboards and wood trim and on the floor. You can look at the floor to see if there's evidence of protection. Because when the flashover occurs, if there's an object on the floor underneath that object isn't going to burn until the object is burned. So you can have, say boxes. It will leave you a nice rectangular area that's not burned. And people look down at that and they say, why didn't that burn? And the obvious answer in most cases is it was protected from the radiant heat that happened during the flashover and subsequent showroom involvement.
Based on your review of the photos, testimony, and expert reports in this case, did you conclude that some of the areas in this house reached flashover?
Yes.
Your Honor, at this point, I've given some leeway. I'm going to object. Flashover, there's no indication this is anything new. I don't know how this would relate to the motion. All we've had testimony from the expert is there was a debate about it in the 90s, which would have happened before this trial happened. We're not here today to have him state he disagrees with an opinion. He's here to testify whether there's changes in the rule, law, or science. And clearly he has not indicated flashover is anything different between now and when he said the 90s when there's arguments on it.
What do you have to say about that, Mr. Charles?
Yes, Your Honor. May I confer with counsel for a minute? Your Honor, in Mr. Lentini's report, he stated that the state's experts were being misled by the burn patterns as a result of flashover. So we're just trying to lay the foundation and introduce that.
And Your Honor, my response to that would be the fact, an argument that the investigators were wrong is not new evidence. That's been brought up at trial, it's been brought up in this first motion. If there's no change in the law as it relates to flashover, that's irrelevant to this motion hearing.
So you have to say about that, Mr. Chairman.
Your Honor, we're trying to provide context for Mr. Lentini's opinions and how he's going to testify about his analysis of the state's experts.
And Mr. Donaldson is saying there's no change in the context, and so you don't have to go through that. Is that what you're saying, Mr. Donaldson?
Yes, Your Honor. The basis of the motion is new fire evidence. There's been no testimony related to new fire evidence related to flashover, or what we have is another expert testifying now that he disagrees with the original opinion, providing no update in the evidence or the fire guidelines between when this trial happened. They're just throwing another expert up here to disagree.
All right, so I'm going to ask the attorney, law student, to go ahead with the next area, because it's not due to the change, and you're not dealing with what those arguments are. So you may go ahead and direct the witness to specifics about the change.
Okay. Thank you, Your Honor. Mr. Lentini, I want to talk about something else that you wrote about in your report and have briefly mentioned today. What is ventilation in the fire investigation context?
Ventilation, when a fire becomes fully involved, is the most important aspect of fire development. And in fact, as I showed with the 2017 versus 2014 slides from NFPA 921, flashover is not particularly new, but our understanding of the mechanisms of flashover and how it works is definitely new. Starting in 2005, some agents from ATF brought out an exercise that they had been using previously in their academy to the public. And they flashed over a room and then asked fire investigators to go read the fire patterns and pick the quadrant of the room where the fire started. And most of them got it wrong. 3 out of 53 investigators correctly identified the quadrant. And this was because a ventilation pattern was created in this test fire that people did not recognize as a ventilation pattern. And when this 2005 exercise was published, finally in a peer-reviewed article in 2008, it became clear that people were not understanding everything that was going on. So yeah, we knew that the floor would burn, but we didn't know really how to interpret post-fire artifacts until we understood the ventilation. And that didn't happen until at least 2005. And it didn't even get published until 2008. And NFPA 921 didn't put it in there until 2014, when the work done by Andrew Cox with the ATF explained the way to interpret fires in a fully involved compartment. Before that, there wasn't any formal way to interpret such damage. And ventilation was the key. I mean, the catchphrase is, if you don't understand the ventilation, you won't understand the fire. And that's new stuff. It was not an NFPA 921 until 2017.
Can you describe how ventilation is relevant to this conversation?
Yeah, we had a bedroom with a door closed and a fire and depleted oxygen. Outside that bedroom, we had a hallway that was open to the stairwell and had no significant limitation on the amount of oxygen available. So once that fire's in the hallway, it's free to burn more completely than in a bedroom where there was less oxygen.
Was ventilation a commonly known and studied concept in the early 2000s?
In some quarters, I'm sure it was, but it didn't make it into NFPA 921 as a consensus that the rest of the fire science community agreed with until 2014 and 2017.
In the 2000s, did investigators still sometimes make mistakes by failing to properly account for ventilation?
They do.
And in this fire, did the investigators adequately consider ventilation in their analysis?
I do not believe they did. They saw burning in the hallway, which was in some cases more intense than the burning in the bedroom, but that, in my opinion, was due entirely to the availability of oxygen out there in the hallway as opposed to in the bedroom.
I'm now going to project some photos again. First up is what has been stipulated as Defense Exhibit P.
And this is marked, this is Exhibit 19.
19.
On the one that's going to be in the file, is it going to be marked as P or Exhibit 19? Or both?
It'll be P, Your Honor. Mr. Lentini, how is this photo relevant to your analysis of ventilation in this case?
This is a view from the bedroom looking into the hallway at the top of the doorway. And the condition of the sheetrock, the wallboard in this case, it clearly was exposed to a hot gas layer. Inside the bedroom, the ceiling is there a way to use a pointer on this? No. The ceiling is still in place. I don't know if it's getting ready to fall down, but it's still in place. Whereas on the other side of the doorway, the sheetrock ceiling has fallen down and exposed the rafters, the ceiling joists, to flames, and those are charred. Inside the bedroom, they're not. So you've got heavier charring out in the hallway, and this caused, from what I can tell, people to say, well, the hallway is where the fire started. But this is normal progression of the fire from an oxygen poor environment to an oxygen rich environment. And so you would expect more burning in the hallway as a result of the oxygen.
Your Honor, I'd like to clarify that this is Defense Exhibit S, not P.
All right, so what we're looking at right now, with the view from the bedroom looking into the hallway at the top of the doorway, is, what exhibit?
Defense Exhibit S.
All right, has that been admitted as well by stipulation?
Yes, Your Honor.
So the next slide I'll be projecting has been stipulated as Defense Exhibit X. Mr. Lentini, how is this photo relevant to your analysis?
This just shows the difference in oxygen concentration out in the hallway and in the bedroom. Bedroom oxygen was, at least at some point, depleted by the hot gas layer, and out in the hallway, the oxygen was not depleted. It was at 21%.
Moving on. In your report, you discussed the state's reliance of depth of char in their analysis of this fire scene. Can you please describe the basic process of depth of char analysis?
Well, it's basically done with eyeballs. I don't know that anybody actually measured the depth of char. There is severe charring just outside the bedroom. There's a closet on the left, and you can see this shiny, we call it shiny alligator char blisters. And it just says that it charred, but it's perfectly normal for that to be charring if the fire's blowing out of the bedroom with unburned products of combustion, and they're unburned because there's no oxygen in the bedroom. They get out in the hallway, they can burn, and so this is typical of what you see on the exterior of a structure where flashover occurred. The fire blows out the windows, and you see it. The burning is not happening inside. There's heating happening, there's pyrolysis happening, but you don't get any flaming until those hot products of combustion get outside and have an air supply. So this is the same thing that happened here. When the fire moved from the bedroom to the hallway, it's got plenty of air. When it's in the bedroom, it doesn't have plenty of air. So you'll get more depth of charring. In fact, in the bedroom, the ceiling joists weren't exposed, so they couldn't be charred. Whereas in the hallway, the sheetrock failed, and that exposed the ceiling joists, and they charred. And so people looked at the ceiling joists, and they thought, the ceiling joists are burned. Fire must have started out here.
Does NFPA 921 include any cautions about relying on depth of char?
It includes a lot of cautions about relying on depth of charring. It gives you cautions about how to measure it, what kind of tools to use, and it tells you that the deepest char is not necessarily where the fire started.
Did the state's experts in this case appear to you to improperly rely on depth of char in their investigation of this fire?
Yes, particularly Dr. DeHaan, when he was describing the charring in the ceiling joists, he thought that was very significant and indicated that the fire must have burned longer in the hallway, therefore it started in the hallway.
Your Honor, do I have permission to approach the witness? Your Honor, before we approach the witness, there's one more slide we'd like to project just to orient the court with the House. Mr. Lentini, I'm now projecting what has been stipulated as Defense Exhibit R. Can you please explain what this is?
This is a not very good drawing of the second floor of the residence.
And do you know where this came from?
I don't. Presumably it would be one of the fire investigators on the scene that prepared the sketch.
And to orient the courtroom, if we're standing in the hallway looking at Robin's bedroom, which side is the bathroom on and which side is the closet on?
The bathroom would be on the left, the closet would be on the right. You could put yourself at the top of the stairs and turn to the right, you would be looking into the bedroom.
Your Honor, do I have permission to approach the witness?
Yes, you may have to look to witness whatever you like.
Thank you, Your Honor. Mr. Lentini, in your report, you cited to various parts of Mr. DeHaan's report for the prosecution. I've handed you what's been stipulated to as Defense Exhibit Y. Can you please ignore the handwritten comments on there? And first, can you please flip to pages 6 and 7, and review the highlighted portion stopping at the end of the first highlight on page 7.
All right, at the bottom of page 6, it is written, "The damage to the rafters above the east end of the hallway was entirely consistent with a substantial fire in the hallway, causing failure of the drywall and subsequent travel of the fire eastward toward the bedroom."
And is there anything in that highlight that's relevant to this conversation on reliance on burn patterns?
Yeah, it's an interpretation of the burn patterns that is totally at odds with what I believe really happened. You've got the fire traveling into the bedroom, and I believe the fire traveled out of the bedroom. The other word that he uses is entirely consistent, and that's not what we're looking for. Something can be consistent with a lot of things. What we're looking for is something that is uniquely consistent with the damage. And you know, what we see here, I just see over-reliance on charring of the rafters as meaning something. What it means is that the sheetrock failed and the rafters burned. But it doesn't tell you when that happened, and I don't believe it happened early in the fire, and in fact, for reasons we'll get into later, I don't think it could happen as was proposed by the state.
Now, can you read the second highlighted portion on page 7 of Mr. DeHaan's report?
Yes, it said, "The door was found in the fully closed position, but there was an area of surface thermal damage from a floor-level plume extending along the north bedroom wall beside the latch side of the door." I don't know what all that means. We do know that the door burned. And once the top of the door is gone, then there's an oxygen supply coming into the bedroom through that open portion of the door. And in fact, we see what looks like an upward pattern caused by ventilation. The problem with all of this is that a fire is a very dynamic situation, and so when you start out with the door closed, you got no oxygen in the bedroom, and then when the door burns open, you've got oxygen coming in the top of the door. So you will get burning along the wall. But I don't think this floor-level plume is real.
Next, can you flip to page 10 of Mr. DeHaan's report and review the highlighted portion on page 10?
It says, "The fire damage patterns to the bedroom door, adjacent walls, ceiling, trim, and carpet were entirely consistent, with a large fire burning just outside the bedroom door for some 20 minutes or more. The fire penetrated the hollow core door at its top, allowing the fire to enter the bedroom via hot gas layer extension." There's so much wrong with that sentence. The first thing is that there was a fire existing in the hallway for 20 minutes.
Again, I'd object. We're here if there's new evidence, new testimony. We're not here for another expert to disagree with the experts who testified at trial over a difference of opinion. That came up at trial. There was an expert testified that came up in the first motion. If they want to stick to how the change in law or how the change in the fire community relates to this, that's fine. But we're just going line by line about how this expert disagrees with the original expert, which is not the nature of this hearing.
What do you have to say about that, Mr. Charles?
Your Honor, may I confer for a moment?
Go ahead.
Thank you.
Your Honor, since this is a systemic issue that keeps rising, may I have permission to address it, because I think it actually
Now,
goes
you
to...
may have your student, if he wants to do this job, he needs to be prepared to do the job.
Sure,
So
thank you.
that's our thing, of course. All right, why don't we take a recess for right now? We'll take a recess and we'll come back in about 10 minutes.
Thank you.
All right, we'll be in recess. Where's John going? All right, so we are back on record in regard to People versus Boes, and it's been brought to my attention that MCR 8.120 in regard to eligible students has a little more than I read initially, and it's necessary for the student to certify in writing that he or she has read and is familiar with the Michigan rules of professional conduct and the Michigan court rules. Have you done that, Mr. Charles?
Yes, Your Honor.
Where is that? I haven't seen it.
May I address that, Your Honor?
Go ahead.
Yes, so as part of,
Excuse me, your microphone is not picking up.
sorry.
Thank you.
As part of getting clinical students ready to practice, they do sign that assertion, which is on file at their office. I've never been required to submit that to the court, so we haven't submitted that.
Well, go ahead and state what your name is, first of all.
Oh, sure, Imran Syed on behalf of Ms. Boes.
All right, so it does say that you must certify it in writing. The court doesn't have that, so I'm going to ask you to do that over the lunch hour, give that to the court, and move it in the court file then, to make sure that we're complying with all the rules. It's also necessary for the student to take an oath, which is equivalent to the Michigan law lawyer's oath. So has he ever done that?
Yes, and that's also signed in writing.
Did you provide a copy of that to the court?
Again, no, that's, our understanding of the rule is that that needs to be held on file. We'd be happy to.
All right, so I'd like to get a copy of that from you as well.
Okay.
All right, so during the lunch hour, you'll have the student who's doing the examining prepare the writing, and also get a copy of the oath over to this court.
Okay, Your Honor.
All right, so I'm going to also give the student an oath, so I'm going to have the student raise your right hand. And the oath goes as follows. You promise to support the Constitution of the United States, support the Constitution of the State of Michigan, maintain the respect due to courts of justice and judicial officers, never seek to mislead a judge or jury by any artifice or false statement of fact or law, maintain the confidence and preserve inviolate the secrets of the client, abstain from all offensive personality, advance no fact prejudicial to the honor or reputation of a party or witness, unless required by the justice of the cause, and in all other respects conduct yourself personally and professionally in conformity with the high standards of conduct imposed upon the members of the State Bar of Michigan. And what is your answer, Mr. Charles?
Yes, Your Honor.
All right, so you promise to do all those things as required by the Michigan Rules of Professional Conduct?
Yes, Your Honor.
All right, thank you. All right, you may continue. We'll go ahead with the next question. Was there an objection that we dealt with or not, or was there?
Yes, Your Honor, I was objecting again to the nature of the questioning being, having this expert critique the testimony of other witnesses based on his own opinion when this motion's about new evidence. And you gave the defense time for response.
All right, so Mr. Charles, what's your answer to that?
Yes, Your Honor. Mr. Lentini's testified that ventilation and the unreliability of depth of char analysis are new evidence, and he's commenting on how the application of that new evidence is material in this case and how it misled the investigation, which we feel is a critical point in a 6500 motion hearing.
All right, so as long as you have the witness testify about the change and where that change is coming from, and a change of science about fire, that's agreeable, but to talk about specifically that prior report is not going to be allowed.
I'll make sure to point Mr. Lentini to addressing what is new and how it affects the prior credibility of these state's experts.
Are you agreeable with that, Mr. Johnson?
I have no problem with him asking about prior testimony, if it's related to something he can show as new evidence.
Okay, let me go ahead.
Thank you, Your Honor. Okay, Mr. Lentini, next, I'd like to discuss some of the trial testimony from the state's expert that you cited in your report. Your Honor, this is an excerpt from the trial transcript of Mr. John DeHaan at trial. I've handed you pages 1129 and 1130 and 1132. Mr. Lentini, can you please read the highlighted portion starting on page 1129 and then both highlighted sections on page 1130?
There is a photograph taken from the same position, the landing at the top of the stairs looking to the east, but in this case the camera is aimed down a little bit so we can actually see the floor and the remains of carpet and pad on the floor. And now I can see a pattern of damage that extended down through the floor, which is especially severe in the east end of the hallway. And then it is a matter of trying to identify what kind of fuel could have supported a long, prolonged fire like that. So it is now a matter of looking at other fire patterns, not only to establish where the fire was most intense, but also what fuels were present or could have been present to support the fire.
Can you comment on the relevant?
I'd object. That skipped a big chunk in the middle of that testimony. I'd ask that the full testimony be read instead of the parts that he just finds appropriate.
All right, you may go ahead and have him read that entire section as opposed to just picking out a couple sentences from the beginning and then the end of that.
Yes, Your Honor. Mr. Lentini, can you please read the whole section, including the non-highlighted part?
Okay, you want me to start on 1129 at the bottom?
Yes, please.
Okay, I've read that.
Go ahead and read it over.
I'll read it over, thank you. There's a photograph taken from the same position, the landing at the top of the stairs looking to the east. But in this case, the camera is aimed down a little bit so we can actually see the floor and the remains of carpet and pad on the floor. And now I can see the pattern of damage that extended down to the floor, which is especially severe in the east end of the hallway. And then it is a matter of trying to identify what kind of fuel could have supported a long, prolonged fire like that. And looking around at the adjacent fire surfaces, we have painted sheetrock on the walls. We have wood trim on the doors. The drywall itself really won't support any fire. The paper coating on it will eventually burn off, but that is a very small contribution to the growth of the fire. The wood frame of the closet door, and we have carpet and pad. Those last materials are combustible, but they don't generate a lot of heat. They don't produce a lot of energy. They don't burn with very big flames. So it is now a matter of looking at the other fire patterns, not only to establish where the fire was most intense, but also what fuels were present or could have been present to support the fire. Question. In your evaluation, what fuels do you believe contributed to the damage in the hallway? Answer. Well, certainly the inside or facings on the hollow core door. Question, and that would be the bedroom door. Answer, that would be the bedroom door, and that would burn fairly quickly, produce some heat. The additional fuel items we are talking about That's
it. That's the end of the highlight
okay.
section.
And then it's not continuous.
No.
It goes to
That page skipped at 1131.
Yeah.
page
You can stop there,
1131.
Mr. Lentini.
Okay. The first full answer on page 1132 is Certainly, a distribution of flammable liquid on the clothing as well as on the carpet would be exactly what would be needed to produce the size of localized fire at the end of the hallway. Question. And in viewing the carpet area going into the northeast bedroom and door area, you may refer to those photographs or exhibits which are behind you. What, if any, indicators assisted you in coming to your conclusions regarding those? Answer. Well, I looked at the overall fire pattern where the damage to the wood was most significant, where things were burned, where they were not burned, where the deposits were just on the surface, smoke or soot staining on various surfaces, as well as where those things were burned completely away. And that is basically how I assess the progress, duration of the fire, and how much of those individual materials are consumed.
And again, Your Honor, I'd object for rule of completeness. They skipped an entire page, and I don't want to accuse it of being disingenuous, but on page 1131 is a full page of him giving his reasoning why he reaches that conclusion. So I have to wonder why that page was excluded when given to this witness to testify about it.
What do you have to say about that?
Your Honor, these were portions of the trial transcript Mr. Lentini reviewed and then commented on his report, and we're trying to elicit his testimony from his report.
Right, so if you have page 129 and then 130, and you skip one for 1131, and then you have 1132, it does seem like, why would you move out 1131?
We'll have Mr. Lentini read 1131 too, if Your Honor permits.
Okay, go ahead.
Can I get a copy made, Your Honor? I have it fresh. I don't think they have a copy in front of them. Is there?
All right, we have a copy machine right here, so that will work. So this is not marked as an exhibit, correct? This is
No.
referencing the prior testimony.
Yes, Your Honor.
At pages 1129, 1130, now 1131, and also 1132.
Yes, Your Honor.
So the witness could start at 1130 on questions of 1130 after the highlighted portion. And then continue on with 1131 and 1132.
Okay. So this is second to the last question on page 1130. Question. In your evaluation, what fuels do you believe contributed to the damage in the hallway? Answer. Well, certainly the inside or the facings on the hollow core door. Question. And that would be the bedroom door. Answer. That would be the bedroom door, and that would burn fairly quickly, produce some heat. The wooden framing of the doors would eventually contribute. So there were basically up in here plywood or basically solid wood doors to the small closet. That would generate some flame. And even when you have the synthetic carpet on the floor, that would also support a fire. But even combining all these together, in my experience, it did not create a large enough fuel load at that end of the hallway if those were the only things available. We looked at the contents of the closet and perhaps clothing that somehow got involved in the closet. And yes, clothing will support a fire, but it is not a very energetic fire, especially if there is a lot of cotton clothing present. So even adding the clothing to the potential fuel load, I still can't account for that damage. And ultimately, that ultimately led to my interpretation that there was an additional fuel load present that would, we can't see after the fire, and could not chemically identify the residue after the fire. Question, do you have an opinion as to what type of additional fuel items we are talking about based on your investigation? Answer, certainly a distribution of flammable liquid on the clothing as well as on the carpet would be exactly what would be needed to produce that size of localized fire at the end of the hallway. Question, and in viewing the carpet area going into the northeast bedroom, and you may refer to those photographs or exhibits which are behind you, what, if any, indicators assisted you in coming to your conclusions regarding those? Answer, well, I looked at the overall fire pattern where the damage to the wood was most significant, where things were burned, where they were not burned, where the deposits were just on the surface, smoke or soot staining on various surfaces, as well as where things were burned completely away. And that is basically how I assess the progress, duration of the fire, and how much of those individual materials are consumed.
Mr. Lentini, can you comment on the relevance of this testimony to your investigation with respect to depth of char?
Yes. There has been recent work published by Mealy, Benfer, and Goddick on a USDOJ grant about flammable liquid fires. And the flammable liquid fires on carpet with gasoline go out or use up all the gasoline after 5 minutes. And it really doesn't depend on how much gasoline you use. You get more heat release if you use more gasoline. But the amount of time that this gasoline on carpet actually burns is about 5 minutes. And it diminishes considerably after that. So, and this is newly published material. You're not going to get 20 minutes of burning. You're not going to get enough burning to cause the ceiling to fail without a whole lot of gasoline. And the test that I've seen done with 5 liters of gasoline would only expose the ceiling to flaming combustion for 2 or 3 minutes at most. And that is not considered enough to cause the sheetrock to fail. So this is why, this new study, new published study, it says you're not going to get 20 minutes of burning out of it. You can't. And it also says that it's not going to cause significant char. When the gasoline was poured directly onto smooth surfaces, it caused superficial damage. It did not cause heavy charring. And it put to rest the idea that flammable liquids could burn a hole in the floor as well.
Mr. Lentini, I'm now going to hand you an excerpt from the prosecution's expert Michael Marquardt's trial testimony transcript. Can you please read the highlighted portion just on the first page of the excerpt I've handed you, which is page 601 of the trial transcript?
Okay, the question was, do you have any initial thoughts or initial impressions as to the scenario here? The answer, my initial impression, based on examining the interior of the scene on July 31st, is that there was an extreme amount of damage in the hallway. It didn't appear to be enough fuel load in the hallway to cause that amount of damage. The fire patterns, the indicators, led back to the hallway as the area of origin.
Can you please explain how this is relevant to your depth of char analysis?
The depth of char is largely controlled in this situation by the amount of oxygen available to the fire. not the fuel load that's present, but the amount of oxygen that's present. And so you have the fire coming out of the bedroom, encountering more oxygen and burning more intensely in the hallway. That explains the extra damage in the hallway, and that ties directly to the work that Steve Carman published in 2008 about ventilation and how it confuses fire investigators into picking the wrong origin.
Can you please flip to the next part of the excerpt I've handed you, which is pages 712 and 713 of the trial transcript? And can you please again read the highlighted portion starting on page 12 and going on to page 713?
Okay. 712 starts with a question. And you understand that laboratory analysis conducted, and they have already been admitted into evidence, which failed to show, based on gas chromatography, the presence of any identifiable liquid petroleum products in the east-west hallway. Does that affect your opinion? No, it does not. Why not? Answer, based on the amount of burn damage to the floor, based on the amount of damage in the hall with the lack of the fuel load, based on the amount of damage to the ceiling in that area, the generally localized heavy burning to that basically half of the east-west hallway near the bedroom, there is not sufficient fuel load to cause that damage. And so I believe an ignitable liquid had to be added to that area.
Can you comment on Mr. Marquardt's testimony there with respect to depth of char?
Again, I'd object just to the nature of they're limiting his testimony in that area to just the inserts they put out, especially on page 601, the first question they asked him. They cut it off mid-answer. He goes on all of page 602, all of page 603, all of page 604, all of page 605, all of page 606, all of page 607, all of page 6, up to the top 608, giving reasons to qualify that answer. And again, I think it's disingenuous. We're cutting off parts of his testimony to try to say that this is all he relied on. That's my objection. I'd ask for completeness and for the rest of his answer, especially in 601 to be given.
What do you have to say about that, Mr. Charles?
Your Honor, may I confer with counsel for a moment?
Go ahead.
Thank you. Your Honor, the full transcript is on the record, and if the state would like to bring that up on cross, they may. But if Your Honor would prefer, we can read more of the transcript onto the record.
To put in part of the answer, and just the very first part, the court does believe that you need to have the full answer right into the record, as opposed to just the first few lines. It sounds like this is a pretty long answer. So that is the answer, so I'm going to put the doctrine of completeness. You should have the complete answer.
Okay, Your Honor. Your Honor, we're going to pull the complete answer from the transcript.
You can start over on the answer on page 601, read that first 6 or 7 lines, and then continue on with the rest of it.
Yes. My initial impression, based on examining the interior of the scene on July 31st, is that there was an extreme amount of damage in the hallway. It didn't appear to be enough fuel load in the hallway to cause that amount of damage. The fire patterns, the indicators, led back to the hallway as the area of origin. Again, as I stated, as the fire rose, it leaves predictable indicators and patterns that I am able to follow back to the area of origin. There was considerable damage to the floor in the hallway with a fairly localized area. That would be approximately, there was damage to a good portion of the floor in here, as the pictures depict. There was heavy damage to the ceiling directly above that area. And then the patterns indicated that the fire extended from the hallway north into the bathroom at the ceiling level. And how I am able to determine that that is the damage within the bathroom is up high at the ceiling level. Next paragraph. When fire develops, it goes up and out. Fire creates hot, buoyant gases and smoke byproducts. Those are lighter than air, so they rise. As it is burning, it entrains, it is the scientific term, but it pulls in fresh air around it to continue. It needs oxygen to continue to burn. So it entrains that air, heats it up, and it's lighter than the surrounding air because it's heated up and it rises. That smoke, heat, and other byproducts leaves patterns as it develops. Again, there was heavy damage, but it was fairly localized into this hallway and it developed up and out from there. The damage within the bathroom was up high at the ceiling level. There was more damage on the closet side, on the hallway side of the door frame than on the bathroom side of the door frame. This indicates that the fire traveled from the hallway into the bathroom. Going down this hallway, the damage became progressively less and less and was up high at the ceiling. Again, it progressed from floor level up to the ceiling. The hot gas layer is up at the ceiling and it can't go any higher because it is hitting the ceiling. So it starts to travel out horizontally along the ceiling level. This is why we have chimneys above fires in our fireplaces, because hot gases and smoke rise up and out. New paragraph. The damage to the closet. There was considerable damage to this closet. However, on close examination of the closet, all the damage was pretty much from mid-level to ceiling level within the closet. And looking at the door frame around the closet, there was much more damage to the exterior side of the door frame than to the interior side of the door frame. Looking more closely within the closet, the wood construction and the drywall within the closet was much more heavily damaged up high. And as I got down lower in the closet, there was much less damage, to the point where the first 3 or 4 feet above the floor was a pile of debris. And that debris was all considerably damaged on the surface. But as you dig into the debris, there wasn't any fire damage in there. New paragraph. Fire, in order to occur, needs 3 things. It needs a fuel, and when I speak of fuel, I'm talking about anything that will burn, not just liquid, but this wood table is a fuel to a fire investigator, a piece of furniture. Clothing is a fuel. It needs oxygen and an energy source, heat, to get started. And then there is another equation to that, and that is a chemical chain reaction. It has to get going enough to continue the process. As the fire burns, it adds heat back to the fuel to heat that fuel up, to vaporize or pyrolyze that fuel in order to get it to burn. Next paragraph. When the fire is burning, fuel is not actually burning the solid material. It is burning the vapors that are created above the solid material by the heat. This is true for liquid and it's true for solid materials. If you look at a piece of wood in your fireplace, the luminous flame that you are seeing is actually above the wood because it is only burning where the vapors from the fuel and air can mix together and burn. There is no oxygen down in the piece of wood. Technically there is air, oxygen in there, but it is not in the proper state for it to burn. Next paragraph. As the piece of wood is heated, it is pyrolyzed, basically vaporized, produces vapors that mix with air, and an energy source that causes that to burn. I explain all that to explain that this pile of clothing and debris here could only burn on the surface, where the surface layer is heated up, could vaporize the clothing so it could mix with air and combust. Underneath number 1, which is not heated enough, and number 2, there is not enough air down there to get it to burn. Next paragraph. So the damage within this closet was up high and caused by extension from the hallway into the closet. Again, the damage up there in this north-south hallway was caused by extension from the east-west hallway down towards the south. Within the son's room, which is identified as Bill's room, it had some heat and smoke damage, no more than that. I did notice from the fire department overhaul, which is where they search through into hidden areas such as wall cavities. They will often tear out pieces of ceiling or wall to get into the hidden areas to determine if there are any hot spots. Next paragraph. Moving backwards toward the west, above the landing at the top of the stairs, again, the fire damage was up high at ceiling level from extension from this area within the hallway. Next paragraph. There was some burning to the top of these two doors, which would be expected based on the extension. There was fairly heavy smoke, medium smoke to some heat damage within this bedroom, the master bedroom. Next paragraph. The area of the door was again burned off, and there is some extension into this closet, but very minimal. And again, in this area up high at the ceiling, in this location, and in this location, here, there was evidence of fire department overhaul where they ripped the ceiling down. Next paragraph. Also in this hallway, there was evidence of the fire department overhaul. As I moved into the victim's bedroom, there was less damage than in the hallway. And there was evidence that the fire had burned through and burned off the top of the door and extended into the victim's bedroom. The heat, the damage, and smoke was from the top down, and that's expected, again, as a fire burns, the hot gases and smoke and soot rise. They make contact with the ceiling, and then they spread out along the ceiling. We call that a ceiling jet. You can almost visualize filling up your bathtub and flipping it upside down. As the water fills in, it fills in around the drain, and it slowly makes its way across the horizontal surface, and it meets the container. If it fills from the bottom up. In a fire situation, you flip that over. The hot gases burn through the top, burn from the ceiling down, and leaves an identifiable heat and smoke pattern from the ceiling into the room. Next paragraph. There was also some additional burning on the bed surface over there. Apart from that, most of the damage in that room, there was some heat and smoke damage down low, but there was no incredible damage to the carpet, anything of that sort. There was melting to the surface of the carpet, approximately 18 to 20 inches as you entered the door. Generally, with those observations, my first impression of the scene was that we had an origin in this hallway and the fire burned up and out from there. How far are we reading?
To the end of the answer.
Okay, well, there's a question now.
Okay. Thank you, Mr. Lentini. Now, can you comment on that testimony with respect to depth of char?
With respect to depth of char, he was just relying on it as guiding him to the origin. He was relying on the deepest char burning the longest. And we know that that's not necessarily true, and that didn't become generally accepted until well after 2008. People knew about it. People knew that fire investigators had difficulty in fully involved rooms. But the first published literature on the subject happened in 2008 when retired agent Steve Carman published his paper about the 2005 experiments that were conducted in Las Vegas and subsequent work that Agent Carman did.
Thank you, Mr. Lentini. We'll get to Steve Carman's report. Overall, can you comment on how Mr. DeHaan and Mr. Marquardt's use of burn pattern analysis would be received in today's profession?
They would get more questions about fuel load and why they think it's so important. Generally, they were talking about burning up high, and they were considering what could have burned. And they did not seem to consider the possibility that what could have burned was the hot gas layer that came from the bedroom into the hallway and burned intensely when it encountered more oxygen.
Would you agree that depth of char was not the only mode of analysis that Marquardt and DeHaan took?
Yeah, they looked at, the totality of the circumstances, but mostly they seem to have focused on how much fuel was there in the hallway to account for the damage to the ceiling.
Do you still feel that their use of burn pattern and char analysis in particular was outdated in this case?
Yes.
Moving on. Did NFPA 921 provide cautions about relying on depth of char ever since the first edition in 1992?
It does.
And in the 1990s and 2000s, were there studies done on this subject by the ATF?
Hey, Grant, I'd object, Your Honor, if this was all in the 90s, this is not new evidence.
What do you have to say about that?
Your Honor, we're trying to just lay the foundation for why this would be considered new evidence.
So the court's going to ask you to move on to what you're here for, so you will go to that.
If this concept was around in the 1990s and 2000s, why is it considered new evidence today?
It wasn't put into NFPA 921 until 2014, 2017, when the controversy surrounding the 2005 experiment, 2008 paper was addressed by the Technical Committee on Fire Investigations. There was significant changes between 2014 and 2017 about the impact of ventilation on fires and why it made the correct interpretation of post-fire artifacts, such as depth of char, less relevant than people used to think it was.
And why was this addition to NFPA 921 controversial if it had been around since the 90s?
What was controversial was the publication of a study that showed error rates related to burn pattern analysis in the 90% range, where only 3 out of 53 people reading fire patterns in these tests could correctly identify where the fire started. So it was very controversial when it first came out. And it remained controversial. There was an article in 2019 where it was discussed in the literature about what Carmen's work meant and what it didn't mean.
Was there anyone who knew about the results of the study or this information before the Carmen paper?
Sure. ATF had been running experiments going back into the 90s, and they knew that something was causing fire investigators to get it wrong. I don't know that they knew about what exactly it was until after the 2005 experiment when it came out. Prior to the 2005 experiment, ATF kept all of this knowledge about how often fire investigators were misled by ventilation-generated patterns. They kept that to themselves. The tests were done anonymously and nothing was published. ATF didn't even admit it until 2010 when some of the other agents involved said, yeah, we knew about that. We knew people made mistakes, but they didn't have a very good understanding of why those mistakes were being made until Andrew Cox of the ATF started doing his work somewhere around 2010. And he didn't publish or publicize his work until 2013 when he came out with a technique called origin matrix analysis. So it was in 2013 when people first started focusing on how important ventilation is and how it can mislead fire investigators to the wrong origin.
Thank you, Mr. Lentini. Mr. Lentini, what have I just handed you?
You just handed me Steve Carmen's 2008 report, which he made to the International Symposium on Fire Investigation and subsequently published.
Does this appear to be an accurate copy?
I have no reason to believe it's not.
So, Mr. Lentini, you testified that the Andrew Cox paper was important in the fire investigation profession. Why do you believe that was important?
Because it helped us understand what happens in a fully involved compartment and how ventilation affects that. And when I first saw Agent Cox make his presentations sometime after 2010, I was very impressed with his ability to articulate what's going on here and why are people getting it wrong so frequently.
Moving on, I'd like to discuss another term you used in your report. Are you familiar with the term negative corpus?
I am.
And can you explain to the court what that is?
That is the methodology that a fire investigator can use to say, well, I'm looking at this evidence and I don't see an ignition source or an accidental ignition source here. Therefore, it must be an intentionally set fire. That's basically it. But you can say, well, I don't see any flammable liquid here. It must have all burned away without any evidence that that really happened. So it's reaching conclusions without evidence. It's short for negative corpus delicti. It's like doing a murder trial without a body.
Can you describe how NFPA 921 has treated the negative corpus reasoning?
Yes. People knew that it existed, and we discussed it in the 921 committee, probably starting around 2000. But the committee did not want to credit that particular method of analysis, and so they didn't mention it. The words negative corpus did not appear in NFPA 921 until 2011. And it became a problem, and one of the reasons that negative corpus was disparaged in 2011 is that people had misused language that had been in NFPA 921 since 2001. In 2001, we put in a statement to allow fires to be called incendiary when they were obviously incendiary, even though the ignition source had been taken away. And what we said then, in 2001 and again in 2004, was that in rare cases, if you have what's called a clearly defined origin, it's legitimate to say this must have been set with an open flame. And the fire investigation profession took that language and abused it. And they said, well, its origin is clearly defined to me, and that's not what we meant at all. What we meant was that anybody could go up to this fire and say, I see this, I can tell you where the fire started. What an untrained person could do with this evidence. So if an untrained person can walk in a room and say, yeah, that's where the fire started, because that's the only place that's burned, that's legitimate. What happened after we put that language in the document was people started saying, well, it's clearly defined to me, and the clearly defined origin might be 400 square feet. And anything outside of that could therefore be eliminated as a potential fire cause. And so it was because of the abuse of that language that was present in 2001 and 2001, 2004, and 2008 that the committee threw up its hands, basically, and they said, people are using negative corpus here, and we don't want them to use negative corpus. So we had originally allowed the use of something, we didn't call it negative corpus, but something similar to negative corpus early on in very circumscribed situations, which do not apply here. And it's people saying, oh, this is a clearly defined origin, that made the committee lose that language altogether. And they came up with a negative corpus prohibition or disparagement.
Just to be clear, what was NFPA 921's stance on negative corpus in the 2011 edition?
In the 2011 edition, it was said it's not scientific, it shouldn't be used because it causes the development of untestable and therefore invalid hypotheses. And that language has stayed. The language around that, the paragraphs around that have changed a little bit, but negative corpus is still disparaged to this day as a means of determining the cause of the fire.
In your review of this case, did you find that the investigation of the fire employed negative corpus?
With respect to the fire in the hallway, yes. With respect to the fire in the bedroom, you got a gas can in the bedroom. There's no question this is an incendiary fire in the bedroom. But in the hallway, where there's no evidence of gasoline found in the chemical tests, they said, well, there's not enough fuel here, and therefore it must have been added gasoline, even though there's no evidence of the gasoline. So yes, they used negative corpus methodology when they were considering what happened in the hallway. Now the bedroom, yeah, it's pretty obvious. In the bedroom, you got gasoline all over the place. So that's not a negative corpus determination. The negative corpus determination was used in the hallway where they thought the fire started.
And can you explain why you think it's wrong to conclude that there must have been an ignitable liquid poured in the hallway?
You need evidence for ignitable liquid. We have very, very sensitive techniques for detecting ignitable liquid. And the size of the fire that's being postulated in this hallway is enough to fail the ceiling. And that's a big fire, like a megawatt. To put it in context, a typical wastebasket fire might be 50 kilowatts, might be 100 kilowatts. A megawatt is what you get when you light a chair on fire.
Have you read the report of the prosecution's new expert, James Lord?
I have.
And after reading that report, do you continue to believe that Mr. DeHaan and Mr. Marquardt relied on negative corpus?
I do.
I'd now like to refer you back to an excerpt from Mr. DeHaan's trial testimony. I will hand you a copy. This is page 1134 from the trial transcript during John DeHaan's trial testimony. I've highlighted both the question and answer on page 1134. Can you read both, please, Mr. Lentini?
Question: how can you explain that damage? Answer: well, at this point, one would look for a fuel source that would drive a big enough fire to accomplish that damage, and there isn't. If I have, for instance, a large upholstered chair or a Christmas tree or something like that, I could produce a very large fire in a small space that can produce that kind of damage. But in this case, I have no remains of a Christmas tree or large chair. Next paragraph. I have clothing, remains of the carpet, I have the door liner, and that leaves me kind of short of energy, if you will, short for the fire. And the only thing that I could identify that would increase that kind of intense fire at that location would be a flammable liquid that ends up getting burned away substantially during the fire.
Can you comment on the relevance of this to the use of negative corpus?
Yeah, again, I don't object, as, again, a certain portion of an answer is given here. He further explains why he believes this in the next 2 pages. again, they're trying to give short versions of answers to negate an opinion when there is pages more of explanation related to it.
All right, what do you have to say about that? It also indicates that the witness, the third from the last highlighted line, I think said would increase with that kind of intense or something. The word create was not stated, I don't remember what word it was, but in any event, transcript will stand for itself at 11:34.
Your Honor, how much of the transcript would you like Mr. Lentini to read?
What are you thinking, Mr. Donaldson?
Aaron, I think a follow-up question is upon what did you base your opinion on, and please refer to the exhibits. I think at least that question and answer should be read in to give reasoning to why he gave the answer above. Again, they're trying to take a summary and say that's all he relied on and cut out the part where he explains it. So I'd ask at least through page, until Mr. Zessen cuts him off on 11:36 should be read in.
Are you agreeable with that?
Yes, Your Honor.
All right, we're going to start on 11:34, the next question that was not highlighted yet.
Mr. Lentini, do you still have the full transcript in front of you?
I don't think I go up to page 1100.
Sure, I'll trade.
No, this goes to 790. Okay. So we talked about getting burned away substantially during the fire. The next question. You testified earlier that the door to the northeast bedroom was partially opened. Is that correct? Answer, yes. Question. Upon what do you base your opinion, and please refer to the exhibits, that the door was closed to the, certainly, could we clarify, Your Honor, that the door was partially open at the time of the declaration? The court, okay. And this is DeHaan again. This is exhibit 49, and this shows the area in the east end of the hallway where the carpet has been and the pad has been burned away. To the right is the foot of the closet with some of the burned contents of the closet still present. And there is some carpet remaining here on the left side of the hallway. But the question was about the position of the door. This photograph shows that there is basically a line right across the closed position of the door. The door itself has been burned very badly, and when the fire crews entered, they pushed the remains of the door in, so the door itself is not in this photograph, or at least portions of it. Part of the flame still remains. But what is significant here is that we have a kind of sharp line across where the door, in its fully closed position, kept some of the fire damage away. But more significantly, there is an angled pattern of damage inside the bedroom, on the carpet inside the door. And it basically starts there and extends back about 8 inches, so to a point about there. And this is basically where the door would swing in its normal position, or, its normal travel, because there is a lot more fire. And there's an objection.
I think that's fine, Your Honor.
We good?
All right, thank you.
Thank you, Mr. Lentini. Can you please comment on how that is relevant to our discussion about negative corpus?
He couldn't find enough fuel to justify what he perceived as excessive damage to the ceiling, and then hypothesized without evidence that it must have been a flammable liquid. And when that hypothesis was tested in the laboratory, it came back there was no flammable liquid in the samples submitted from the hallway. There should have been. If there was gasoline in the hallway, there should have been plenty to be detected there. And so he's taking no evidence and saying, well, it must have been, despite the fact there's no chemical analysis that says there was that.
Do you believe the state's investigators in this case use negative corpus reasoning that would no longer be allowed under NFPA 921 today?
They would certainly get cross-examined extensively on the issue of negative corpus with respect to their conclusions about what happened in the hallway.
So is it possible for the gas in the hallway, if there was gas there, to be burned up during the fire itself? Is that a possibility?
Just barely. Our techniques for detecting gasoline, we can detect a 500th of a drop of gasoline in a hallway. This is something that we developed during the 1980s. Prior to that, we had very insensitive methods of detecting trace amounts of ignitable liquid. But our techniques were improved during the 1980s for separating out the gasoline. So prior to, say, 1990, a negative laboratory report wasn't really important. But after 2000, a negative laboratory report means there's nothing in the can. Doesn't mean anything at the scene, because you got to rely on the investigator to get the stuff into the can. But we can detect so small an amount of gasoline that these days our concern is more with false positive samples than with false negative samples.
All right, so the question was, can the gas, if there was gas that's used in the hallway, be all burned up during the fire?
It's possible, but unlikely that it would be undetectable.
And again, Your Honor, I'd object that this part relating to gas not in the hallway is not new evidence, as it was brought up in the trial, cross-examined to, and as you just heard testimony to, that technology was in the 80s and 90s.
All right, so what are you objecting to?
Any testimony related to the lack of gasoline being a factor in why this isn't, because that's something that's already been addressed by the court and Court of Appeals and everything.
Right, you agree with that, Mr. Joe?
Your Honor, I think the lack of gasoline is relevant to the use of negative corpus and how it impacted this investigation.
Okay, and how is the negative corpus, how does that change is what you can get into, but not in regard to the test for a flammable liquid?
I'm sorry, Your Honor, can you repeat the question?
So you can get into what relates to any change of evidence or your position of the change of evidence, but not in regard to what was discussed specifically at the trial.
Your Honor, the new evidence isn't that there was or wasn't a lack of gasoline in the hallway in the test. It's that NFPA 921 stance on that type of analysis has changed since then.
Okay, so you can get into that.
I actually want to move on from negative corpus now, Mr. Lentini. And I want to talk about some other scientific developments in the fire investigation field since 2006. First, I want to talk about a study you briefly mentioned earlier, conducted by Mealy, Benfer, and Goddick in 2001. Are you familiar with that?
I am. It was not 2001, though. It was 2012.
12, apologies. And can you describe what that is and how it's relevant?
Yeah. The Hughes Associates, where Mealy, Benfer, and Goddick worked, got a grant from the Justice Department to explain the behavior of flammable liquids and what you might expect to see after a flammable liquid fire. And the report is 300-some pages long because they did all different kinds of surfaces and all different kinds of fuels. But the relevant portion that I have focused on deals with gasoline on carpet, which is the subject of this particular case.
I'm now going to project some more slides, which have been stipulated to as defense exhibits. So I'm now projecting what's been stipulated as defense exhibit AA. Can you explain how this is relevant to that study?
Yes, this is a chart plotting the heat release rate of a test fire over time. And the green and blue lines of this chart are of gasoline on carpet. The red lines are kerosene on carpet. Kerosene lasts a little bit longer than gasoline, but the gasoline peaks at 350 kilowatts, which is not enough to reach the ceiling, at about 2 to 3 minutes. And then it falls off, the heat release rate falls off. And so at 300 seconds, you can see that the heat release rate of this particular fire is considerably diminished. It's not going to cause any significant damage, certainly on the ceiling. So these people said, okay, this is what a liter does. What happens if we use a lot of gasoline? If we use 5 liters? And they presented that data as well. But I think the next slide just shows a cutoff at 300 seconds.
Yeah, the next slide is Defense Exhibit BB.
Right. And I've just added that red line just showing where 5 minutes is. And this is important, and again, this is from 2012. After 5 minutes, this gasoline on carpet, this liter of gasoline on carpet, is mostly gone, and it's certainly not releasing enough heat to cause damage to the ceiling. So when they saw this, they said, well, let's explore what happens if we use a gallon of gasoline, or actually, the next one is 5 liters of gasoline.
The next slide is Stipulated Defense Exhibit CC.
Okay, and in this case, the gasoline is shown in blue, the kerosene is shown in black. And the total heat release rate goes above 1,000 kilowatts. It goes up as high as 1,200, but only for a short period of time. And this was a key coming out of this study, that you've got to account for the time element when you're looking at the damage after a fire. And in this case, in order to get to the ceiling, you're going to need a kilowatt to get up to have a flame height that's tall enough to reach the ceiling. And in this chart, it shows that you get above I'm sorry, when I say kilowatt, I meant megawatt, 1,000 kilowatts. That happens at about 2 minutes. And by 4 minutes, it's gone. It's down, again, it's down to where the flame is not tall anymore. The flame can't be causing damage to the ceiling. So the statement that there's a 20-minute fire caused by gasoline is disproved by this new research that was published in 2012. It's just not going to last that long. And this is throughout the paper, almost 300 and some pages of it, over and over again. The fact is that the ignitable liquid is so volatile and burns out so quickly that it's not going to do as much damage as people think it does. And again, I think the next slide, I put another red line at 5 minutes. Yeah, right there.
Yeah, and this next slide has been stipulated as Defense Exhibit DD. I'm now going to project some pictures of the Boes residence. Can you walk us through these pictures and how the study is related?
Okay.
The first one is Defense Exhibit EE.
Okay, so we're looking at the hallway here, and the damage to the ceiling was bedroom doorway. This charring is what both DeHaan and Marquardt relied upon to conclude that the fire started in the hallway. And then they didn't find sufficient fuel load in the hallway, so they hypothesized that it must have been.
All right, I'd like to move on now. Based on your review of the evidence in this case and new standards and new evidence, where did you conclude the fire originated?
In the bedroom.
Please explain why you think that.
The bedroom exhibits damage caused by a hot gas layer, which is what you would expect if the fire started in that bedroom. There was an explosion in the bedroom of gasoline vapors sufficient to lift the roof. And that is not something that would happen late. It wouldn't happen after 20 minutes of burning in the hallway and then the fire finds its way into the bedroom and there's an explosion. That's just not going to happen, particularly as the state opined, the door was open. If you have a bunch of gasoline on the hallway floor, trailed into the bedroom, it's going to take a matter of seconds from ignition in the hallway to ignition in the bedroom. On the other hand, if you have ignition in the bedroom, it will take some time to burn through the door and come out into the hallway. So this damage that we're seeing, although the state said it happened first, it didn't. It happened late in the fire, after the bedroom doorway was breached. You could not have the deflagration sufficient to lift the roof if that door was open, because it would have vented out the door. So they, again, made up this scenario that an explosion in the bedroom caused the door to slam shut. But the question is, how did the fire get into the bedroom if it didn't start there?
What is your conclusion regarding the position of the door before and during the fire?
Closed. The door was closed. There's no evidence at all that the door was open, except in the hypothesis developed by DeHaan and Marquardt. There's the evidence that the door was open is not at all persuasive.
And based on the new evidence and new standards, how did the fire spread into the hallway?
It started with an explosion in the bedroom, and then banked down and lit some of the other materials in the bedroom on fire. But it had time burning in the bedroom to develop a hot gas layer that we've been talking about the whole time here. That hot gas layer eventually burned a hole at the top of the door and allowed the hot gases to come out through the doorway, mix with the oxygen that was available in the hallway, and make a big hot fire. And that's what failed the ceiling, and that's what charred the ceiling joists.
Can you tell the court what a deflagration is?
It's a low-order explosion. An explosion where the flame front proceeds at less than the speed of sound. If it's faster than the speed of sound, it's called a detonation. But it's basically an explosion.
And what role did Mr. DeHaan believe deflagration played in this fire?
Not clear to me, because he said the door was open to start with, and so you've got to have the door open in order to follow the alleged gasoline into the bedroom. And then at that point, he said the force of the explosion caused the bedroom door to close and lift the roof.
And what's your opinion on that?
I think the door was closed the whole time. And I don't see any evidence that it was ever open at any point during this fire.
You've testified that the fire started in the bedroom, and the state's experts theorize that it started in the hallway and then spread to the bedroom. Can you describe why you believe their theory is unlikely?
Yeah. Number one, we know that the gasoline, if it was present, wouldn't last long enough to fail the ceiling. We know that there's no evidence in the hallway of gasoline. We know that if the fire had started in the hallway on gasoline that had been poured there and then completely evaporated, it would have progressed into the bedroom immediately. There would have been continuous layer of gasoline vapors at the floor level And if that door's open, it's going into the bedroom. We know there's gasoline in the bedroom, the gasoline can's in the bedroom. So there's no evidence of gasoline fumes or gasoline vapors in the hallway. There is evidence of gasoline fumes and vapor in the bedroom. So the evidence says it started in the bedroom, not in the hallway.
Are you aware that the prosecution relied on the fact that there were supposed marks in the carpet and flooring, which they claimed proved the door was open for a significant part of the fire?
Yes, I've looked at that.
I don't know how the door opening and closed, this was argued at trial, how any of this is new evidence.
What do you have to say about that?
May I have a moment to confer, Your Honor?
Sure.
Thank you. Your Honor, this is responsive to the prosecution's new report by James Lord that the state relied on these marks.
I don't know what you're talking about, so, Mr. Donaldson, do you have any comment regarding to that statement?
My overall comment is whether the door is open or closed has nothing to do with new evidence or not. You've had testimony about their supposed negative corpus argument, you've had testimony about their char argument and all that. Now we're getting into how this expert thinks the fire happened, which is, and that our experts were wrong, which goes back to an issue that's been dealt with multiple times.
All right. Mr. Charles, do you have anything else you want to say about that?
No, Your Honor.
All right, the court's going to agree with the prosecutor on that. So you may get into new evidence, but I'm not going to rehash everything else previously said.
Okay, Your Honor. Moving on, I'm now going to project on the screen what has been stipulated as Defense Exhibit LL.
How long are you going to be with this witness, do you think?
We only have a few more questions, Your Honor, approximately 15, 20 minutes.
Okay, go ahead.
This is a picture of, excuse me, can you explain what this is?
This is a picture of two matches on the bedroom floor, one of which is apparently burned.
And the next slide is stipulated as Defense Exhibit MM. Can you explain what this is?
Yeah, it's a wider view, and it shows that there's a whole box of matches in the bedroom.
Mr. Lentini, I've just handed you an excerpt from Mr. Mike Marquardt's trial testimony, which is page 678 of the trial transcript. Can you please read the last answer on page 677, the page before, through the end of the highlighted portion on page 678?
Okay, so on page 677, they're talking about ignition sources. moving up to the second floor in the area of origin and then into the victim's bedroom, I looked at numerous different potential ignition sources. Questions such as, within the victim's bedroom, there's electricity. Electricity also has to be considered. Again, keeping in mind that, I believe my area of origin at this point is still in the hallway, but I needed to consider other potentials. So I looked at electricity. There is electricity in the room. There are electrical appliances in the room, including a TV, computer, several associated small appliances underneath the desk on the floor. I believe there was a fogger, a strobe light. There were extension cords, power supply cords under there. There were 4 electrical outlets. I examined those and didn't find any indication that they were involved in the ignition of the fire. Plus, I didn't believe they were in my area of origin. In addition, as part of my investigation, I examined the electrical system in the house. So I look at the electrical service panel, which is located in the garage. I photographed that. As part of my investigation, I also determined if the occupant has had prior electrical problems, and I found no indication of that. Also, within the victim's bedroom, there were candles and there were matches, both unused and numerous used matches. So I examined those and documented those. However, I didn't find that they weren't in the most likely area of origin at that point, so I eliminated those as possible accidental causes. And this goes directly.
Your Honor, again, I'd object, as has been the pattern here, they're stopping before he explains why he found that reason. If we continue on to the middle of page 679, he'll explain why he didn't find that to be very particular evidence. So again, they're picking and choosing parts of testimony here to make it look good for them.
So the court's going to ask you to continue on 678 where you left off in the
Okay.
middle, and then continue on to 679 to where specifically, Mr. Johnson?
I'd say at least through, until the bottom of 679 before the last question. That's where he explains why he indicated he didn't find those matches in particular.
Let's continue that then.
Question. You saw candles, matches and candles in the room. Answer. Yes, that is correct. Question. And did you seize them for evidentiary purposes? Answer. No, I took photographs of them, which is documenting them. Once I found more than one burned match, I found numerous burned matches in that room in assorted different sizes.
Different areas.
Different areas. I documented that with photographs. Based on the number that appeared that they were germane to the scene, there were candles there. It would make logical sense that there would be burned matches in the room. Question. What do you mean germane to the scene? Answer. Part of the scene, something that is used on an everyday basis. Question. So how does that affect your evaluation of potential pieces of evidence? Something that is there on an everyday basis. Answer. If this is there, if there are a number of them, that doesn't, it's a potential cause, but it doesn't mean that it did cause the fire. Question. Is there a difference, referring to the matches now, is there a difference in your opinion as to finding one match in a potential origin area as opposed to finding a box of matches or a box of matches strewn about? Answer, yes. Question, how so? Answer, if I would have found one burn match, that would have caught my attention more than finding 10, 15, 20 burn matches. But when you find that many, it means that they are used on an everyday basis, in addition to the fact that there are candles there.
Thank you, Mr. Lentini. Can you please explain the significance of this testimony with respect to new science and new fire investigation standards?
Yes. In 2008, NFPA 921 in the chapter on origin determination was changed. And one of the major warnings that came out of that is that the investigators should be aware of the trap of circular logic. That is stating that because this potential ignition source is not in my hypothetical area of origin, I can eliminate it as an ignition source. And the warning against using circular logic like that it first appeared in NFPA 921 in the 2008 edition in a completely rewritten chapter on origin determination. So he was advised not to do that.
To be clear, do you believe the use of circular logic impacted this investigation?
I do. When you get the wrong origin, you're in a position of saying, well, this is the origin, so I can eliminate everything that's not in my area of origin. And what 921 says about that is that such determinations should be subjected to increased scrutiny, because if you find an area of origin where there's no ignition source, then you might want to rethink your area of origin. And that should have happened here.
Your Honor, I've been informed that we have a couple more areas of questioning than I initially thought. I think we might be able to shorten things by conferring. Could we have a short break to confer?
Let's take a lunch break right now, and we'll see you back in an hour at about after. Or adjourn.
sciences, when it got seen electronically, they pulled it from a file, whatever, the prosecutor file or something, it was, they only had one.
You may have a seat on. We're going to go back on record now in regard to people of the state of Michigan versus Karen Boes. Is that saying the name correctly, Boes, or how do you, I see Ms. Boes is present in the courtroom. How do you say your last name? How do you say your last name?
Bruce.
Bruce, okay.
I don't say it that way, but around here we do, yeah.
Well, how do you say it?
Bowles.
All right, and I'm saying.
That's how everybody else
So
calls me.
all right, very good. So Karen Boes is also present, has been present. And this is file number 02264455C. We're continuing on the evidentiary hearing. It's now 1:15. We may continue then. Where were we at the last, when we took a break? Were we at an objection, Mr. Johnson?
No, I don't think we were at an objection. They just asked for a quick break to
Oh, yeah,
confirm.
consult
Yeah.
with each other. Okay. So you may go ahead then and give your question.
Thank you, Your
The
Honor.
witness is still under oath, so you may go ahead and state your name.
John Joseph Lentini.
Thank you. You may go ahead.
Thank you, Your Honor. Mr. Lentini, you testified earlier that you had a chance to review the report of Mr. Lord. Do you have a response to Mr. Lord's assertion that the state's experts relied on a totality of factors and did not employ negative corpus?
I read that. I disagree with it.
How so?
Well, they used negative corpus in the hallway. They said there's no ignition sources here. There's not enough fuel here, so no ignition sources means somebody used an open flame and took it away. Not enough fuel means somebody must have used a flammable liquid and it all burned up mysteriously, because it didn't all burn up in the bedroom.
Mr. Lord also commented on the Carmen study. Can you comment on what that study consisted of and whether or not you continue to believe it constitutes new science today?
Yes, it was hidden science back before the 2005 experiment was conducted in Las Vegas, where 2 rooms were set up and 53 investigators were asked to pick just a quadrant of the room where the origin was. And in those 2 rooms, 3 guys got it right, got the right quadrant in room number 1, and a different 3 guys got it right in room number 2. And so when Carmen presented that, it was new science. People went crazy because it was alleged in this particular experiment that the error rate was north of 90%. The experiment was repeated at the ATF laboratory using instruments to understand what was going on. And then it was repeated again in Oklahoma City, where 70 investigators were asked to pick the quadrant of origin in 3 separate fires. And when the fire burned for 3 minutes, 75% of the investigators were unable to get the correct quadrant. So they identified the correct quadrant exactly the same number of times they would have identified it if they had picked it at random. And this shook fire investigators who were paying attention to their core. And it prompted Andrew Cox to study the problem. And he came up with a framework for how to think about it, which wasn't published until 2013. And it made it into NFPA 921 in 2014. So, and people were still arguing about it in 2019. So it's new and it's controversial, and I can't agree that it's not new science.
Thank you. I'd like to move on now Your Honor, I would like to clarify for the record that there was an objection earlier to Mr. Lentini opining on the position of the door. The fact that Mr. Lentini did not address the position of the door in his report was mentioned as an important issue in this court's ruling on our prior 6500 motion. If Your Honor would allow, I'd like to ask a few questions to address that.
What's your position in regard to that, Mr. Donaldson?
I have no objection to that.
Go ahead.
Apologies, Your Honor. I'm lost in my notes here. Okay, here we go. Okay, Mr. Lentini, I'm going to walk you through some more photos, which have been stipulated as defense exhibits, to talk about the position of the door.
Okay.
First being projected, Mr. Lentini, this has been stipulated as defense exhibit HH. Can you comment on how this picture is relevant to the position of the door?
Well, there's no door visible in this picture here because it's been pushed out of the way. This is the doorway area prior to excavation. So it shows debris on the floor. It shows a piece of, that's what I believe is carpet padding from the hallway that's been flipped over in the center right of the photograph. So this just shows the door before there's any excavation.
And the next picture has been stipulated as defense exhibit II. Can you comment on this?
This shows the door after excavation. And you can see the carpet where the door protected it during the fire while the door was closed. And there's no controversy about that I'm aware of. But what you can see on either side of that is that you're looking at the floor. You're not looking at the carpet, except right there in the threshold area. On either side of the door, it's been scraped down to the wood. And there's a diagonal line inside the bedroom that people thought indicated the position of the door. And that diagonal line is in wood. That's a scrape in the wood. The only time that door would provide any indication of its position would be while the carpet is still there. It would protect the carpet. But this line on the floor, the carpet's gone. So the door is not going to cause damage to the floor underneath the carpet. All the door can do is protect the carpet. The other thing we see there is that the side rail of the door on the right is not burned, which indicates it was closed and protected from the fire and not exposed to the fire.
And this next slide is defense exhibit JJ.
Okay, and there we are. There's everything I just talked about illustrated.
And the last slide related to this line of questioning is defense exhibit KK.
Yes. So again, you're seeing a scrape in the wood, which doesn't indicate that the door was in that position.
Thank you. I'd like to move on now. There was a question earlier about whether you presume a fire is accidental until proven otherwise, and you said yes. Is that correct?
Not in this case. That position that I took was about being the first guy to show up at a fire scene and going to be the one to do all the processing.
When you are the first one to arrive at a fire scene, is that the approach you take?
That is the approach I take, and I look for evidence to disprove that. And if I find it, then there's no longer an accident, and I have gone an extra step. I've gone an extra step beyond just saying what I see. I'm saying went in here thinking it was an accident, and now the evidence shows me that it's not. And that, you know, I worked in Georgia and in the Southeast, and in all those states down there, the law is that it's accidental until proven
I object.
otherwise.
There's no relevance to what the law in other states are.
That's correct, so let's just focus.
Yeah, we'll move on.
Just gonna strike that.
May I proceed, Your Honor? Are you familiar with a fire textbook called Kirk's Fire Investigation?
I am.
And the primary author of that textbook as of 2012, was that John DeHaan, the same expert who testified for the state in this
Yes,
case?
beginning in 1983, he took over the publication of that. The original was written by Paul Kirk in '69. DeHaan took it over in '83 and wrote the second edition, and then he wrote subsequent editions. I actually corresponded with him on a regular basis between 1983 and the late 90s.
I'm now going to show you page 660 of the 2012 edition of Kirk's Fire Investigation.
Your exhibits?
No.
Can I see who he's looking at before I?
No.
Do you want to see projected?
Do you have?
You guys got
do you
it.
have-
Control Kirk's. Page number.
Is that your motion?
No, this is just responsive to your question.
Why don't you let the prosecutor look through this
Here.
Check.
tablet right now, and then you can show up your witness. Are you gonna make this an exhibit, or what is this for? You're showing your computer then to the witness. Are you gonna make this an exhibit or not?
Your Honor, this is responsive to a question Mr. Donaldson asked earlier. So we didn't have a chance to make this an exhibit, but if Your Honor, the prosecution would prefer, we'd be happy to admit this page or this entire chapter as an exhibit.
Well, I have no idea what you're even talking about, so I'm not presenting here. You have is this gonna be an exhibit, or what is the purpose of what you're showing your computer to the witness for right now?
Yeah, we will introduce this as an exhibit.
The one page is on the computer right now?
The whole chapter.
What's the purpose of the whole chapter?
To include the entire context of the excerpt that we plan on having Mr. Lentini read onto the record.
Right, and what's the title of this chapter?
I believe it is arson as a crime.
Witness has a book, so I don't know.
Okay.
And how many pages is this chapter approximately? And what's the relevance of it? I don't think we read any more chapters than I already read, so that's why I'm asking.
If you just want to admit that page, I'm not going to argue or will completeness on that one. It's just a
Okay.
very basic generic quotes. I'm fine
Yeah.
with that.
Okay. Your Honor, there's been a stipulation to just admit the specific page, which is page 660.
Yeah, you can get that then. Is that correct, Mr. Johnson?
That is correct, Your Honor.
Perfect, thank you.
Mr. Lentini, can you please read the highlighted text out loud?
Legally, there is always a presumption of innocence even as to the cause of a fire. A court will assume that a fire was caused by accidental means or by natural means, that is, an act of God, unless it can be proven beyond a reasonable doubt that no accidental or natural cause was present.
And is that in line with your view on presuming a fire is accidental?
It is.
Thank you.
And what was this page from, what document was it? It doesn't sound like it'd be a jury instruction, so, was it?
No, that is from Kirk's fire investigation,
Okay. Page 666?
660, 660.
All right, thank you.
I have just a few more questions, Mr. Lentini, to conclude. To sum up your testimony, from your perspective as an expert in fire investigations, was the prosecution's theory and investigation of what happened at 5...
You're asking a leading question right now, so you may ask questions, but don't make it so leading, where you're just asking for a yes or no. Go ahead.
Was the prosecution's theory and investigation of what happened at 532 William Street in Zealand based on methods that would be considered valid today?
Hold on. You're doing it again, you're asking a leading question. It's gonna be a yes or no answer, right? So just asking how do you wanna start your question?
Your Honor, I don't believe it's leading to ask a yes or no question.
Yes, it is. Asking a general question.
May I have a moment? With respect to the new evidence, what is your view on the prosecution's investigation and theory of what happened in this fire?
That the scientific experiments and the scientific consensus about the appropriate way to investigate a fire has changed as a result of the work of Steve Carman. It has changed as a result of the work of the 921 Committee with respect to negative corpus. It has changed as a result of Madrykowski's work on ventilation, and it has changed as a result of Mealy, Benfer, and Godek on the behavior of flammable liquids, specifically gasoline burning on carpet, that was not available at the time of the original trial, and certainly would be major issues if it were to be tried again.
Regarding negative corpus, are there new and different standards in place today that did not exist in 2003 or 2006?
Yes, negative corpus was allowed in very limited circumstances up until 2011. And it was in 2011 that the use of negative corpus was disparaged in all cases.
And has there been a significant shift in consensus on reliance of lowest and deepest char since 2003 and 2006?
Yes, it was the lowest and deepest char that misled 50 out of 53 investigators in the test that Carman published. And it was caused by, the lowest and deepest char was caused by the best available oxygen, as opposed to the longest duration of burning.
Thank you, Your Honor. I have no further questions at this time.
All right, thank you. And Mr. Johnson, you may question the other.
Good afternoon, Mr. Lentini.
Good afternoon.
You agree there's a difference between process of elimination and negative corpus, is that correct?
I do.
And in fact, back in NFPA 921, in November 2000, when there was comments being submitted, we went over a couple of them already, correct? For the first manual?
Yeah.
Okay. Isn't it true that you submitted a comment to have negative corpus as part of that first manual? Language,
I don't know what you mean by the first manual.
or the 2001 manual?
I'm sorry?
Isn't it true that you submitted comments to have as part of that 2001 manual related to negative corpus?
I may well have.
Okay. And beside you was John DeHaan, was he one of the people who was involved in this process?
Yes,
Okay. And isn't it true that he also submitted a comment agreeing with you about the comments, a negative corpus, stating that he agrees with the language that you proposed?
yes,
Okay. So Mr. DeHaan was well aware of your stance and concerns about negative corpus all the way back in 2000, is that correct?
sure.
I'm approaching Peoples, proposed exhibit 1. If you take a moment to look at that. Does that to you appear from the NFPA 921 manual in the comment section?
All right, this is not part of the manual.
Or the comment
Just to be
section.
clear, for the record, this is a report on comments, how the technical committee dealt with suggestions to change the manual.
And this is from the same document that the comments we saw earlier and your direct came from, correct?
Correct.
Okay. And this one was submitted by John DeHaan, is that correct?
It was.
Okay. And can you read what his recommendation was?
Well, he just copied the proposed language that I wrote.
All right, go ahead and read that. That was-
It's long.
Well, if you read what he wrote and then go down to the negative corpus part of it.
Okay. Negative corpus. On occasion, occasions may occur where an investigator has evaluated and identified all potential ignition sources at the point of origin and has credibly eliminated them without finding physical proof of an ignition source. When the point of origin is clearly defined, elimination of all causes other than the application of an open flame is a finding that may be justified. Such determinations are termed negative corpus by the fire investigation community. The investigator should be capable of evaluating all identified potential heat-producing devices in order to credibly eliminate them as as possible ignition sources.
And at the top of that, in the recommendation, isn't it true that John DeHaan states that the language as proposed and revised to this committee is not acceptable and should be rejected in favor of the language proposed by you? Is that correct?
That's correct.
So he shows back in 2000, a few years before this trial even happened, that he understood and agreed with you as it relates to negative corpus.
With respect to the clearly defined origin, which we later had to abandon because people were abusing that language with respect to clearly defined. I wrote that and didn't put in a definition of what I meant by clearly defined in the naive belief that people would know what that meant.
But as it relates to your proposal, DeHaan agreed with your proposal in November of 2000.
He did, and it was put into the document that you could use negative corpus in circumstances where the origin was clearly defined. Now, we don't have a clearly defined origin here, or we wouldn't be here.
Now, let me stop you on that. You indicate even in your own report, 18443, in the NFPA manual under section 18.443, there are times when there is no physical evidence of the ignition source found at the origin, but where an ignition sequence can logically be inferred using other data. Any determination of fire cause should be based on evidence rather than the absence of evidence. However, there are limited circumstances where the ignition source cannot be identified, but the ignition sequence can logically be inferred. Is that in NFPA?
That's in there.
Okay. And it gives you examples of when you can use that, correct?
Correct.
And one of those is a diffuse fuel explosion and flash fire, right?
Yes.
And one of those is also when an ignitable liquid residue, confirmed by laboratory analysis, is found at one or more locations within the fire scene, and its presence at that location does not have an innocent explanation. Is that correct?
Sure, it says that.
Yes, okay. NFPA also states that process of elimination is an integral part of the scientific method, does it not?
It does. It also says that it can be used inappropriately.
Now, where you keep stating that negative corpus is used here as it relates to the hallway, can you show me where in NFPA it states that the liquid needs to be found at the actual origin and not at multiple locations at the scene?
Well, it makes no difference if you find it in the bedroom and you don't find it in the hallway, and 921 calls for confirmed by laboratory analysis.
But does 921 also states that one or more locations within the fire scene, is that correct?
It does, but...
It does not say origin of the fire, does it not?
No, it says one or more locations within the fire scene.
What evidence do you have that the fire started in the bedroom?
That's where the gasoline was. That's where the explosion happened.
Where's the plume inside of the bedroom?
There is no plume inside the bedroom. There's a hot gas layer inside the bedroom at this point.
So there's no plume inside the bedroom?
No.
Now, you indicate that there's a lack of evidence as it relates to the hallway, and you state that the investigators rely on depth of char. Isn't it true that NFPA 921 also allows fire pattern, fire spread, heat, and other sources as ways to determine fire origin?
Well, certainly you look at the fire patterns and you formulate hypotheses as to how the fire spread. But those have to be compatible with the rules of science. And if you have science that says your gasoline fire is going to go out in 5 minutes, you can't account for the ceiling failing.
Now, in that experiment that you talk about with the gasoline fire, well, first of all, let me back up. In this fire itself, do you know the type of drywall that was in the hallway?
It was drywall,
Do you know the type of drywall?
sheetrock.
Do you know what thickness?
No, and it doesn't matter.
Do you know what the fire rating of it was?
I don't. It probably fails in 10 to 20 minutes when exposed to a fire.
So you don't know the thickness of the drywall, the fire rating of the drywall, how much drywall is even there. Is that correct?
That's correct, and it doesn't matter.
The amount of drywall present doesn't matter as...
It'll slow it down. If you put fatter drywall in, it'll slow down the transmission of heat through the drywall. This looked just like ordinary residential construction drywall.
Now, you indicated, I believe, multiple times that a fire in the hallway could not have reached the ceiling. Is that correct? In your belief of the crime scene here?
The fire that...
If it was on the carpet, it wouldn't have been able to reach the ceiling. Is that what you testified to?
It depends on how much gasoline you use. If you use a whole gallon, it will reach the ceiling, but it will only reach the ceiling for a couple of minutes. It won't reach the ceiling for long enough to fail it.
And did you do testing based on that?
No, this is well known that it takes what it takes to fail drywall.
Okay. And what reports are you basing that off of?
Just experience.
And what tests or experience is that based off of?
2,000 fire scenes shoveled out.
And what calculations did you use in those fires?
No calculations are necessary.
Okay. And what diameter fire did you assume in those? Okay.
I'm sorry?
What diameter of fire did you assume in those, any experiments or calculations you did?
Whatever 5 liters spreads out to.
So you can't give me a single fire or test or report you're basing this off of?
I think the Mealy, Benfer, and Goddick report that I have excerpted and presented to this court shows clearly that the gasoline fire proposed by Dahan and Marquardt couldn't cause the ceiling to fail.
Now, you talked a lot about this Carmen report in the ATF training, is that correct?
The Carmen report?
Yep, based off of an ATF training where you indicated multiple times 3 of 53 people got the right answer.
Yeah, that was when they finally went public with that knowledge.
No, when they finally went public, so that's something that the ATF would have known about before then, correct?
Yes.
Okay. And
But they
beside Carmen...
Excuse me.
No, wait for this
Wait,
Beside Carmen, who authored that report, who else was involved in that training?
Mark White,
Yep.
Dan Heenan, and Jerry Haynes.
So one of the persons giving this training that you keep citing was one of the people who testified in this case, Mark Watt, is that correct?
Correct.
So he would have had knowledge of this if he was giving the training on it.
People had knowledge that investigators got it wrong. What they didn't have knowledge of is why they got it wrong until after Carmen's work was done.
And Mark Watt was part of that work with Carmen, correct?
I don't know how much he stayed involved after the 2005.
But he was certainly part of that experiment you keep talking about, where
He was part of the experiment.
he was one of the presenters of that
He
experiment.
was. And he knew that people got it wrong, and that's what they knew, is that people misread burn patterns. But understanding didn't happen until 2007, 2008.
Now, you indicate negative corpus, and you talk about the lack of evidence in the hallway. The NFPA doesn't require actual physical evidence, does it? It just says any evidence.
Right.
Okay. And any evidence could include burn patterns, it could include all sorts of other things that when you sat and talked read those 3-4 pages of testimony from Mark Watt, all the stuff he included in his finding, isn't that correct?
Yeah.
In fact, when Mark Watt testifies, he gives a pretty clear understanding of air and ventilation. In fact, his explanation that you read out to the court is very similar to the one you gave, isn't that correct?
Some of it was.
You also, in your report, say that part of the issue you have with Mark Watt and DeHaan's testimony is that their hypothesis can't be tested. Do you remember putting that in your report?
That's correct.
Okay. Is it possible to test a hypothesis where there's no evidence recovered?
I'm sorry?
Do you think it's possible to test a hypothesis where no evidence is recovered?
Where no evidence is recovered?
Yeah.
Sure.
Okay. So you indicate here we can't test the hypothesis because there's no evidence of anything.
No, they tested their hypothesis by submitting samples from the hallway to the laboratory, and the laboratory came back and said, there's no support for your hypothesis here. There's no gasoline detected in the hallway.
And they went on to testify why they believed, despite that, all the other evidence that presided with them, why they still believed it happened in the hallway, correct?
Yeah, and I think they were wrong about that.
Okay. And you think they were wrong. And so did Wolf, who testified at the trial, correct?
Yep.
Okay. So this is the same argument Wolf was making back at the trial.
I don't know.
Did you go over Wolf's testimony?
I did.
Now, you testify that you're positive that this wasn't an accident, correct?
I'm sorry?
You testify that this fire in general, you're positive wasn't an accident.
Right, you don't get a lot of fires that are accidents when you got a gasoline container in a bedroom.
Now, as we pointed out, you believe that they used negative corpus in terms of finding their findings in this case, correct?
With respect to the hallway, yes, sir.
Okay. But again, NFPA doesn't differentiate finding evidence at the origin of the fire versus at the scene of the fire, isn't that correct?
NFPA talks extensively about the origin of the fire, and it talks about what you should do if you get to where you believe the origin is and you don't find an ignition source, you need to treat that origin determination with increased scrutiny.
Negative corpus is defined in NFPA 921 as, well, it states identifying the ignition source for a fire by believing to have eliminated all ignition sources found, known, or suspected to have been present in the area of origin and for which no supporting information exists is referenced by some investigators as negative corpus. Is that correct?
That's correct.
Okay. Now, you don't believe there's two separate fires that happened in the home, do you?
No, I believe there was one fire, started in the bedroom, spread to the hallway.
Okay. So you believe that there was one fire, just like DeHaan and Mark Watt testified that they believe there was one fire, correct?
Right, they just imagined that it started in the hallway, somehow got into the bedroom, caused an explosion 20 minutes later.
So you both believe there's one fire and have difference of opinions where it started. Would you say that's fair?
That's correct.
Okay. But you stating that it happened inside of the bedroom is process of elimination, and them saying it started in the hallway is negative corpus. Is that what you're saying?
That's correct, and there's evidence in the bedroom. There's a gas cannon, and there's gasoline spread around the bedroom. So I'm in real solid ground saying that bedroom fire was intentionally set.
But the definition in NFPA 921 states identifying the ignition source of a fire should not be done through process or through negative corpus, correct?
Correct.
So you both are identifying an ignition source of the fire.
Oh, I
You
think
both
I-
agree there's the same ignition source, correct?
I'm sorry?
You and Marquardt and DeHaan all believe that this was an intentionally set fire.
Correct.
So you all believe the ignition source is the same. You just have different opinions where it started.
They say it must have been an open flame. I think there's a lot of burned matches in the bedroom that is kind of a clue.
But again, that's your argument about where the fire started, and you're using process of elimination to kind of get back to there, because you say that it couldn't happen in the hallway. So you're doing the exact same thing they're doing, except you're calling it process of elimination with you and saying it's negative corpus when they do.
No, that's totally wrong. There's no evidence in the hallway. There's only fire patterns in the hallway, and the proposition that it was set with gasoline should have been, if it really was set in the hallway with gasoline, that those laboratory tests should have come up positive.
Now, the laboratory test depends on what part of the sample was taken, correct?
Sure.
If it was taken from the top layer or the bottom layer of the carpet, would you agree there's a difference?
Yeah, it ought to be, if you pour gasoline on the carpet, it ought to be on the top and the bottom and the middle,
Okay.
and the padding.
Now, you indicated when you're showing the door being open and closed, you indicated that you believe there's no carpet left by the door, is that correct?
There's only carpet left where the door was. There's a strip of carpet across what would be the threshold of the door.
Okay, so your argument is that the door must have been closed because the carpet's there, but the rest of the carpet's burned away, so is it possible that gas didn't get that little section of carpet there from the hallway to the inside of the bedroom?
It could have, but you would expect to see some burning on that carpet. You wouldn't expect to see it protected, and it would happen instantaneously if the door was open.
Now, the other question I have is you testify pretty positively that you believe that there's no carpet in that hallway. Is that correct?
The hallway was carpeted.
But you indicated that the part that they thought was carpet, that meant the door was open, wasn't actually a mark on the ground. Is that what you testified to?
Correct.
Okay. Did you look at the photos that ATF took follow-up on 9/19 of 2002?
I looked at the photos that I have.
And you're positive that there was no carpet found in the hallways or in the bedroom side of the door?
There was carpet about 18 to 20 inches away from the door, but not right there. While we're looking at that scrape, that's not carpet.
So your testimony is there would be no carpet consistent with the door being open?
Correct.
1 second, Your Honor.
Your Honor, I have no further questions.
All right, thank you. Do you have any redirect?
Yes, Your Honor.
Mr. Lentini, can you please explain why this isn't one of those clearly defined areas of origin like the ones you mentioned in your book or in NFPA 921?
This is not a clearly defined origin. It took Mr. Marquardt 3 days of inspecting this before he settled on the hallway. A clearly defined origin, what we meant when we wrote it back in 2001, referred to in this exhibit, People's Exhibit 1, was an origin where you, as an untrained lawyer or your kids could walk into the room and say, that's where the fire started because it's obvious. That's what we meant by a clearly defined origin. And then people start saying, well, there's a question about whether it's in the hallway or in the bedroom. That's no longer clearly defined.
And when did the Carmen study take place?
The Carmen study took place between 2005 and 2008.
And when did this fire occur?
2002.
Thank you. I have no further questions, Your Honor.
Thank you. Do you have additional questions, Mr. Johnson?
No, no, Your Honor.
All right, thank you. May this witness be excused?
Yes.
Yes, Your Honor.
So free to go?
Yes, Your Honor.
All right, so you are free to go?
Thank you. Mr. Passaggio with the exhibits.
You please? Defense may, you may call your next witness.
Your Honor, for the fire portion of this hearing, Mr. Lentini is our only witness. I did want to confer with Mr. Donaldson just briefly about exhibits and then bring the court up to speed about a little minor issue. Could I have just a second to confer with him?
Do you have a witness to go?
Your Honor, I have a witness, but we had scheduled for him to be here tomorrow, so I've gone over fully his testimony with him, and we have tomorrow booked. If the court's okay with it, I would propose we break for that. I come back tomorrow and I can call him as a witness then.
All right, what about the witness sitting next to you?
That's, yeah.
Okay, so you're ready to go and you'll go tomorrow?
Yeah.
All right, and you are none of the witnesses?
For the fire portion, yes, you had set next week for our other witnesses.
All right, so the court's agreeable then to break for today, and you figure out your exhibits and make sure that the court gets a list of what is admitted by
Right.
agreement. And then we will continue tomorrow morning at 9 o'clock with the prosecutor witness, Mr. Lord, and then we will continue at that time. All right, thank you.
Thank you.
Yeah. Okay. Sounds good. I'm gonna have to redo all my exhibits too, because I was talking to Jen about it before. I didn't know if our motion was already in the record, so I was just gonna hand my attachments to the motion, and now they're all numbers. So I'm gonna redo all mine. Or I mean, mine are all letters, so for.